Hello, everyone, and welcome to the University of New Mexico's Tribal Law Journal's 2023 Symposium, 200 Years Since Johnson v. McIntosh, the case's impact on Native communities and tribal governments. My name is Valerie DiBernardo. I am the symposium editor on the Tribal Law Journal. We're happy to have everyone in attendance and want to thank everyone for their contribution to this event. If there are any questions, please use the chat function or electronically raise your hand if the presenter has opened the floor for questions. At this time, I would like to welcome Dean Camille Carey to provide welcoming remarks.
Thanks so much, Valerie. Good morning, everyone. Thank you so much for joining us for the University of New Mexico School of Law's Tribal Law Journal Symposium. I'm Camille Carey, Dean of the UNM School of Law. Thank you so much for being here. It's a really great turnout, and we are so pleased to have so many of you join us here today. As we begin our time here today, I'd like to read our Indigenous Peoples Land and Territory Acknowledgement. Founded in 1889, the University of New Mexico sits on the traditional homelands of the Pueblo of Sandia. The original peoples of New Mexico, Pueblo, Navajo, and Apache, since time immemorial, have deep connections to the land and have made significant contributions to the broader community statewide. We honor the land itself and those who remain stewards of this land throughout the generations, and also acknowledge our committed relationship to Indigenous peoples. We gratefully recognize our history. We are very excited about today's symposium, 200 years since Johnson versus McIntosh, the case's impact on Native communities and tribal governments. Thank you to our esteemed speakers for today's symposium, Professor Matthew Fletcher, Professor Kay Cake Stark, Professor Richard Collins, and Professor Robert Miller. We are so fortunate to have you share your wisdom, time, and talents with us today. Thank you very much to Professor Vanessa Racehorse, the faculty advisor to the Tribal Law Journal. Professor Racehorse is doing a spectacular job with the journal. I appreciate all of her hard work on the journal day to day and her work in organizing this wonderful symposium. Thank you to the senior editorial board and staff editors for their great work on this event. An extra special thanks to co-editors-in-chief Lauren Earls and Justin Lauriano, and the symposium editor Valerie DiBernardo. We appreciate all of you joining us here today. We are so proud of our Tribal Law Journal. The Tribal Law Journal began its work in 1998. The first issue was published in 2001. Since its inception in 1998, over 280 law students have participated in the creation of the Tribal Law Journal. TLJ was established to promote Indigenous self-determination by facilitating discussion of the internal laws of the Indigenous nations. The internal law of Indigenous nations encompasses traditional law, Western law adopted by Indigenous nations, and a blend of Western and Indigenous law. TLJ creates a vital space for important conversations about the law of Indigenous people and contemporary legal issues facing tribes and Native communities today. It brings together the voices of academics, practitioners, and students to lead conversations about Indian law. That the journal is free and available online opens up the conversation to many. TLJ also creates an important space and community for our students at the UNM School of Law. We value that community and what our TLJ students bring to the broader community of faculty, staff, and students. Today's conversation will consider Indigenous perspectives on Johnson versus McIntosh, including discussions of the Doctrine of Discovery and the impact of the case on contemporary issues facing Native communities. Thank you for joining us here today for such an important conversation about the lasting impact of Johnson versus McIntosh and how the modern Supreme Court has applied historic precedent to continue to disadvantage Native communities and deny Native property rights. This is such a vital conversation, and we appreciate your investment in it. Thank you again for being here today, and welcome. Thank you.
Thank you, Dean Carey. We appreciate you for joining us here today, and we appreciate your support of the Tribal Law Journal and our symposium today. Hesselholt, Shania Louis Quest. Hello, everyone. My name is Shania Decker. I'm a current 3L at the University of New Mexico School of Law, and I serve on Tribal Law Journal as the web, social media, and blog editor. And today I get the pleasure to introduce Professor Racehorse today. Professor Vanessa Racehorse is a member of the Shoshone-Bannock tribes and a descendant of the Cherokee Nation and Shoshone-Paiute tribes. She is an assistant professor of law at the University of New Mexico School of Law, where she teaches in the Law and Indigenous Peoples program and is the faculty advisor for the Tribal Law Journal. Prior to joining UNM School of Law, she served as an attorney for the California Native American Heritage Commission, served as a deputy attorney general for the Colorado River Indian tribes, and was an associate attorney at a top-ranked national law firm dedicated to representing Native American interests. She has an LLM in international criminal law from the University of Amsterdam and a JD from Columbia Law School, where she was president of the Columbia Native American Law Student Association. She served on the National NALSA board and was the Blue Book editor for the Columbia Law Review. It is my pleasure now to turn it over to Professor Racehorse to introduce the discussion on Johnson v. McIntosh.
Thank you so much, Shania, and thank you, Dean Carey, for the introductory remarks. I'd like to begin my remarks by adding a little bit more on the Tribal Law Journal's history. As Dean Carey mentioned, the Tribal Law Journal was originally founded in 1998. It was founded by both a group of law students as well as Professor Christine Zuni Cruz, who served as the journal's cherished faculty editor-in-chief and advisor for over 20 years. Now, the Tribal Law Journal is the first legal journal of its kind with a focus on the law of Indigenous peoples, including tribal law. TLJ is intended to promote Indigenous self-determination by providing Indigenous peoples, practitioners, allies, and law students with the opportunity to contribute their own work to the discourse around internal Indigenous law. And when we're talking about internal Indigenous law, we recognize that it is broad-ranging and diverse, and it encompasses traditional law, including oral tradition, as well as Western law that's been adopted by Indigenous nations, and sometimes a blend of Western and Indigenous law. Now, this journal has also evolved over time to highlight discussion around how non-tribal external sources of law, including Supreme Court opinions like Johnson v. McIntosh, can impact tribal nations. And this journal applauds and supports tribal resilience and continued self-governance in the face of such impacts. Now, this year's senior editors and last year's senior editors and this year's staff editors have all organized a wonderful symposium for scholarship on this topic of 200 years since Johnson v. McIntosh, the case's impact on Native communities and tribal governments. So in order to begin this discussion, I also wanted to provide everyone with a brief background on this case as well. So decided 200 years ago in 1823, Johnson v. McIntosh serves as both a foundational Indian law case as well as a foundational property law case. Until this decision was decided, there were differing opinions on and approaches to Indian title here in the United States, or what is now the United States. Colonists had primarily imported English real property law to define their rights in America, but this system was complicated by a real need to establish what rights, if any, Indians had to their own lands. Early European land acquisition in what we now call the United States was this sort of piecemeal combination of outright purchases, occupation without payment to Native people, and the occasional rare conquest. During this period of time in the 1700s and the 1800s, the United States also entered into hundreds of treaties with tribal nations, whereby tribes would cede hundreds of millions of acres of land in exchange for payments and promises made by the United States. There were also a number of land companies who were starting to enter into the United States. There were land speculators who were seeking to acquire native land, and all of them had different approaches and different concepts of what rights Native people had to their own land. Some were paying Native people for land, believing that they had full and absolute title to their land. Others were making lump sum payments just with the idea that they wanted to avoid conflict. And some were just occupying and taking land without payment as well. So the case of Johnson v. McIntosh really starts with the actions of two of these land companies. So we have the Philadelphia-based Illinois Land Company that sought to purchase from these Illinois tribes 2 tracts of land in Illinois in 1773. But this purchase that they made very clearly violated this British royal proclamation that the king back in Britain had issued on October 7th, 1763. And this royal proclamation very clearly provided that no one could purchase native lands without the king's permission, and the king had not granted permission in this instance. This was part of an effort on the crown in Great Britain trying to avoid conflict in the settling of the frontier, which was not working out very well. But this land company had dug up this Camden York opinion that was issued by 2 top Crown law officers. And this opinion, they believed, repealed this royal proclamation. But it was a very, far-fetched interpretation of the opinion. That opinion very clearly referenced land in India, not Indian lands here in the United States. Then we also had another land company, the Wabash Company, who 2 years later in 1775 also made a big purchase from the Pinkeshaw Nation, relying on this same Camden York opinion. So these 2 land companies joined forces, and the United Illinois and Wabash Land Companies pushed forward a legislative strategy for about 50 years to try to get any public authority possible to recognize that the tribes had proper title and that they now had purchased proper title from those tribes. They approached the Royal Governor of Virginia, the Virginia Convention, the Continental Congress, and so on. And they were wildly unsuccessful in this legislative strategy. But again, everyone is having a hard time coming to agreement as to what rights or title did tribes have to this land as well. And during this time, we have the newly formed Supreme Court. We have a newly formed federal court in that jurisdiction where these land companies are trying to purchase this land, or trying to say that they have properly purchased title to this land. So they decide to pursue litigation, and what they really want is a Supreme Court opinion that recognizes that they have acquired proper title from these tribes. And the heart of this case was really supposed to be about whether or not this British royal proclamation was constitutional under the British Constitution. There was a little bit of collusion, or a lot of collusion, between both Johnson and McIntosh, with the parties hoping to reach the same conclusion, hoping that the Supreme Court would recognize that, tribes owned the land and that they now had proper title to the land. So these land companies found McIntosh and got him on board with this plan. And there's this really interesting historical background. I highly recommend Indian Law Stories for more details on what really happened in this collusion between the parties. But there's a very real chance that McIntosh's land never actually overlapped with the land company's land as well. But despite that, the parties in their agreed upon statement of facts actually stipulated that the tribes did own this land, and that the signers had the authority to sign, and that a fair price had been paid, and that the focus should really just be about the constitutionality of the royal proclamation. But what ended up happening was that the Supreme Court only briefly mentions the royal proclamation, which was the party's intended focus of the case. And it's really only mentioned in a paragraph in the opinion. And Chief Justice John Marshall, who authored this opinion, goes into about 20 pages on the discovery doctrine instead. This becomes a case about the doctrine of discovery, not about this royal proclamation of 1763. A little bit of background on the discovery doctrine. This doctrine can be traced back to a series of 15th century papal bulls or decrees, which authorized different colonial powers, I should say Christian colonial powers, such as Spain, to seize land that they quote unquote discover, as long as that they are the first Christian power to make this discovery. So this European and international law then becomes imported into our own federal law in the United States in this 1823 decision of Johnson v. McIntosh. The idea was that Great Britain had acquired underlying title through discovery, and then Marshall goes on to explain that Indian lands in the United States were then granted to the federal government through treaty with Great Britain, and that these grants have been understood by all to convey a title to the grantees, subject only to the Indian right of occupancy. So Justice Marshall recognizes that tribes retain this right to occupancy, and that's what they retain here. They don't retain the underlying title. So what is a right of occupancy? This is also known as Aboriginal title or original Indian title. Essentially, it comes with the right to farm, the right to hunt and fish, the right to gather, and the right of exclusion, but it does not come with underlying title to the land. And the idea was that only the discovering sovereign could extinguish this right, this original Indian right, either through purchase or through conquest. So the court acknowledges that even though the United States holds underlying title to the lands, tribal rights to occupy an area cannot be extinguished unless that tribe properly cedes its rights to the government. And I should recognize that even though this is a deeply embedded principle in one of our foundational cases, Aboriginal title was only first successfully litigated this past year. I believe it was the first time it was successfully litigated in Jemez Pueblo's litigation against the United States over the Valles Caldera. So that is a very historic piece of litigation in firmly establishing Aboriginal title, even though it is a principle that was first set forth in 1823 in Johnson v. McIntosh. So in ruling for the defendant, Chief Justice Marshall definitively establishes that the federal government would not then recognize any sort of private purchases of Indian lands made by any of these land companies or private individuals from tribal nations. So this establishes the doctrine that only the federal government has the authority to enter into land deals with tribal nations. And one of the primary purposes of this rule was to essentially expropriate Indian land at as minimal a cost as possible. And this in turn served to ensure that mass amounts of wealth that would have otherwise been transferred to tribes would not be transferred to them, as Europeans would have otherwise been racing against each other to buy native land. It essentially improves market conditions for the United States to be the only party that can then enter into land deals with tribal nations at this time. I also wanted to recognize that the Pope recently repudiated this doctrine of discovery, recognizing that it does infringe upon the inherent rights of Indigenous peoples in numerous ways. But the basis for this decision and its entire reasoning around the doctrine of discovery and Aboriginal title has since been imported to other settler colonial states. For example, it's formed in part the basis for Aboriginal property rights in Australia, Maori land rights in New Zealand, and First Nations land rights in Canada. So this is an extremely important opinion that has had broad-scale impacts on Indigenous peoples globally. And I very much so look forward to hearing from today's scholars on this topic. And I'd like to thank them in advance for their time and insight. So thank you all for joining us for today's symposium. I will go ahead and turn the event back over to our senior editors and today's esteemed scholars. Thank you.
Thank you so much, Professor Resource, for I think what's a really important background before we get started today. I now just want to take a moment to introduce our first presenter, Richard Collins. Mr. Collins has spent 15 years practicing Indian law with organizations such as the California Rural Legal Assistance, California Indian Legal Services, and Native American Rights Fund. Since joining the faculty at the University of Colorado Law School, Professor Collins has continued to work as a pro bono consultant to the Native American Rights Fund and to Native American tribes, including the Southern Ute Indian Tribe. During the course of his appellate work, he's had a major role in several important Indian law decisions, including United States Supreme Court decisions such as McClanahan versus Arizona Tax Commission. His scholarship focuses also on constitutional issues, and he was the director of the University of Colorado Law School's Byron R. White Center for the Study of American Constitutional Law from 2002 to 2010. Professor Collins has written and lectured on such topics as the religion clauses and their relationship to Indian tribes, the Commerce Clause, and ballot initiatives and referendums. His recent research projects include a treatise on the Colorado Constitution, written by Dale Osterly, an article on sacred sites on governmental lands in the United States, Australia, New Zealand, and Canada, the current revision of Felix Cohen's Handbook of Federal Indian Law, and an article in the Colorado Law Review on lawmaking by citizens initiatives. It's my pleasure to introduce Professor Collins to speak to us today. Thank you so much.
Well, thank you, Lauren, for that nice introduction, and thanks to Vanessa for an excellent review of the details of the Johnson versus McIntosh case, although I don't intend to go back over those. This is a remarkable case in terms of legal education because thousands and thousands of law students have read it. It probably is the best known. Well, it's one of the best known cases in the whole of legal study. It's in every property case book that I know about now, and of course, it's in every case book on American Indian law. And that's been true since about 1980. That's when it all started. And the main reason, as Vanessa made clear, is the extensive, page after page discussion of the Doctrine of Discovery. That was a racist, as she outlined, it was a racist deal among European powers that deserves all the criticism it can get. But in Johnson versus McIntosh, it's almost entirely dictum. So the question then is, what about the holding in the case? Did it matter to tribes? And my thesis is the answer is no. In saying that, I'm at odds with a lot of other people, and that's why I titled my paper for this symposium "Dissenting Opinion," because I guess I am a dissenter. Many scholars, many whom I have great respect for, claim that the decision was harmful to Native American tribes. In other words, they claim that if the plaintiffs had won, or maybe if the case had never occurred, tribes would have been much better off and kept much more land. And I just disagree with that. My principal authority citing is to Professor Joseph Singer of Harvard, who agrees with me on this point. Going back to the discovery doctrine, it had 4 parts. The Johnson decision involved only one of those. The rule that land transfers by native nations were lawful only if made to or approved by the British government before the American Revolution or the US government after. A rule of monopoly control over the subject by the settler government. That rule became statutory law in the 1790 Non-Intercourse Act for transfers after that date. As amended, the Non-Intercourse Act is still on the books. Anyone who studied the subject of American Indian law knows that well. It's now 25 U.S. Code Section 177, and I haven't heard of any move to repeal it. This codified the federal monopoly on purchases from tribes as of 1790. Johnson versus McIntosh, many, many years later, had no effect on that statute. Some critics argue that the Supreme Court should have repudiated the doctrine of discovery in the Johnson case. Would that have provided a basis to find the Non-Intercourse Act invalid? I can't see how, and I've never seen an argument that it did. And if it did, would tribes be better off? My point is that the statute governed the subject by the time of Johnson, and the Johnson decision had no effect on it, had no effect on the subject. That's been true since 1790. So let's go back for a minute to the case books. In the year 2000, Professor Eric Cadiz, I'm not sure how to pronounce his name, but I think that's correct. He's a law and economics professor now at the faculty at William and Mary Law School. He published an extensive article about Johnson versus McIntosh, and that article is cited in a note in every case book since the year 2000. The article was based on a superb job of research. It covered a bunch of subjects. One example was he has one of the best lists of best accounts I've ever seen on how U.S. government agents used coercion and deceit to cheat tribes in making land cession agreements, treaties, and agreements. If you want a real nice catalog of how that was done, look at that law review article. But the case books never cite that part. They refer instead to his claim that the decision in Johnson versus McIntosh was harmful to tribes because it deprived them of better prices for their land that would have been provided in a free market. This involved two mistakes that the case books ignore. First, Cadiz failed to note that the governing rule was codified in the Non-Intercourse Act long before Johnson versus McIntosh. He cited the statute but failed to interpret its effect. Second, his critique was good law and economics theory, but misapplied to tribes. Tribes wanted to keep as much land as possible. Making it easier for tribes to sell their land was just what settlers and state governments wanted. In fact, the Non-Intercourse Act, the rule that Cadiz would abolish, was essential to protect land that tribes managed to keep through the centuries of efforts to take it away. That was even more true at the time of the sales at issue in the Johnson case. The governing rule, as Vanessa told us, was the British government's 1763 decree protecting tribal title. It is considered a major source of native rights in Canada today. It was also relied on in the Johnson opinion, as she noted. Minimally, I agree, but nevertheless. Still, another problem with Katie's point is that for a free market to benefit tribes, there would have had to be a legal system to enforce fair dealing. For tribes, there was no such system until much later in time, until relatively recently. Other critics of the Johnson case claim that the Johnson court's description of tribal land title as a right of occupancy was harmful to tribes. It is hard for me to see why. The opinion said tribal title involved full rights of possession and of internal allocation and sovereign control. Have the critics forgotten that possession is 9/10 of the law? In fact, tribal title was equivalent to a fee simple for its ban, except for, correction. Tribal title was equivalent to a fee simple except for its ban on external sale. The differences are just verbal. The very same title is now described as held in trust by the United States for tribes. Well, now wait a minute. If the title was okay, why did tribes lose so much land? We know the answer very well. Before the 1880s, Native nations were coerced or cheated into cession after cession. These were formal sales of all interests. If the Indian title had then been called a trust title, it would have made no difference. Then came the much greater evil of allotment. Much more land was taken, and in the process, the pattern in land that tribes retain was ruined. Compare reservations that were allotted with those that were not. The difference is stunning. We're all getting a look at one of the spectacular failures of allotment in the book and movie Killers of the Flower Moon. I don't recommend the movie, but I do recommend the book if you're curious. Tribes used to it. Tribes did sue to attack the allotment outrage in the Lone Wolf case, which I know anyone who studied the subject of American Indian law knows very well. For reasons I have never understood and still do not, most critics of the case stress its ruling that Congress had power to override an Indian treaty. Far more important was its ruling that tribal title had no protection from the takings or due process clauses of the Fifth Amendment. That part applied to all tribes, not just the 2 or 3 involved in the lawsuit. Later decisions partly corrected that error, but Lone Wolf has never been overruled, and of course it should be. The court's no Lone Wolf opinion was an abomination by the first Justice White, one of the court's weakest intellects, whose other effort in Indian law was his opinion in Ward versus Racehorse, plus his solo dissent in the Winans case. But Lone Wolf was unanimous, and the court that decided it had talented justices Holmes, McKenna, and Harlan. They surely knew what was at stake. Read the lower court opinions. The Lone Wolf tribes made a strong showing of Fifth Amendment violations. Subjecting the allotment laws to Fifth Amendment review could have unraveled that whole wretched scheme. The court took the cowardly way out and preserved it. To get, I've gone through my basic talk so fast that maybe I should just inject a couple other points to fill in the time. So I'm going to just detour back to the opinion in Johnson versus McIntosh. The opinion had some other points that are often criticized. One is that Indian land can be taken by conquest. This was modified, however, by the court's statement that, quote, humanity demands and a wise policy requires that the rights of the conquered to property should remain unimpaired, unquote. Still another reference in the opinion that's been criticized justly, of course, was reference to Native people as savages, highly offensive, but not nearly as bad as the same thing in the Declaration of Independence. Still another point, the Johnson opinion referred to what the analysts called the terra nullius theory, that was pushed by settlers in the United States. The legitimate use of that theory is that the first person to occupy vacant land has the right to it, but land actually vacant is extremely rare. The improper use was by settlers who claimed that native tribes' possession was too ephemeral to have legal recognition. However, that theory was never accepted in American law, and in fact was deliberately rejected. It was part of Australian law. I think Vanessa made some reference to Australia, and of course it was a terrible thing in that country. They fixed it only recently. Anyway, to kind of wind up my talk and turn it over to questions if you have any, keep bashing the doctrine of discovery. It deserves it. And it deserves a prominent place in legal study. But stop claiming that the Johnson decision was harmful to tribes. It was not. And while you're at it, hammer away at Lone Wolf. That's the worst thing the Supreme Court ever did to tribes. And of course, the tribes were party to that case. So with that, I will invite any questions. And if there aren't any, then we can go on to the next speaker.
Professor Collins, thank you for the presentation. I'll go ahead and open up with a question for you as to whether or not there are parts of Johnson v. McIntosh, even in the dicta, that can be actually helpful to tribal nations in advancing tribal rights. Do you think there are any parts that you could highlight?
Well, the problem with saying there were harmful parts is that the system was completely settled by the Non-Intercourse Act. The system that the Non-Intercourse Act created was this negotiation after negotiation for outright transfers of tribal land to the United States government over and over by treaty up till the end of treaty making, and after that by agreement. And most of those, maybe every last one of them, was a dishonest deal because coercion, deceit were used. As I said, look at the Katie's article if you want a really good catalog of how that was done. But I can't see how the Johnson opinion had anything to do with that system.
I have a question. Professor Collins, do you think that the Johnson opinion would have been written differently if Justice Marshall had recused himself?
Yes, I'm sure it would have, because no other justice on the court was as deeply involved in understanding native law at the time, as we know from his subsequent opinions in Worcester versus Georgia and in the Cherokee Nation cases. I mean, sure, it would have been the outcome would have been the same. It was a unanimous decision, and I assume some other justice. One of the important points, one of the important technical points in the Johnson opinion was it relied on the court's prior opinion in the 1810 case. I'm sorry, I'm blanking it for a second. Fletcher
v. Peck.
Yeah, Fletcher v. Peck, the 1810 case. The 1810 case is based thoroughly on the doctrine of discovery, but the court never mentions it. The court never, in other words, it's really just a difference in the opinions. And of course, the Fletcher case was cited as authority for the outcome in Johnson versus McIntosh, which in fact it is an authority for the outcome. And in fact, the tribal interest was actually argued and discussed in Fletcher, even though it was never argued and discussed in Johnson.
Professor Collins, there's a question in the chat asking if you have any ideas about how to alter the proclamation of 1763 to
I'm sorry, again, please.
Yeah, a question in the chat. Any ideas about how to alter the proclamation of 1763 to allow more concrete tribal rights by changing the analysis of Johnson?
Well, the proclamation of 1763 was British law. And of course, British law just became legally irrelevant in the United States, but it remained the law of Canada, which is why the doctrine is considered a very positive part of Native interests in Canada today. There are all kinds of Canadian scholarship that maintains that point. So I don't know why repealing the 1763 decree would have done any good for tribes. I don't understand that. The Canadians certainly don't think so. I want to repeat again that there's every reason to condemn the doctrine of discovery and its collateral effects. And if the Non-Intercourse Act itself was a codification of part of the doctrine of discovery. So if you think that the doctrine of discovery was anything it touches is evil, then you have to go after the Non-Intercourse Act. But it was the governing law, not the Johnson opinion. After 1790, that is. And the same with Fletcher versus Peck. Again, the Fletcher versus Peck was based very much on the doctrine of discovery, and you can try to go after that decision to the extent that it relied on the doctrine of discovery, but the issue in Fletcher was different then. Well, anyway, I will hang around and listen to the other speakers and find out why they think I'm wrong. So we'll see.
Thank you, Professor Collins, for speaking with us today. We can jump to our next speaker and we will be introducing Professor Kikik Stark. And I have the honor of introducing him this morning. Kikik Stark is a professor of law with the Alexander Blewett III School of Law at the University of Montana. And in this capacity, he is the co-director of the Indian Law Program and the Marjorie Hunter Brown Indian Law Clinic and the American Indian Governance and Policy Institute. He is a Turtle Mountain Ojibwe and member of the Bishu clan. And Professor Stark is a former president of the Minnesota American Indian Bar Association, a Forum Bush Foundation Leadership Fellow, and alumnus of Hamline University School of Law. He worked as an assistant professor with the American Indian Studies Department at the University of Minnesota Duluth, as well as an adjunct faculty member at several institutions. In addition to his teaching experience, Professor Stark served as the Attorney General for the Lakota Band of Lake Superior Chippewa Indians as a policy analyst in the Division of Intergovernmental Affairs for the Great Lakes Indian Fish and Wildlife Commission, and as a policy analyst for the Bad River Band of Lake Superior Tribe of Chippewa Indians. As a practitioner of Indigenous law, Professor Stark has firsthand experience in training students on how to work productively with Indigenous principles and procedures. Along the way, he has helped build institutions grounded in Anishinaabe law and has helped students and communities forge better relations between Indigenous and non-Indigenous institutions and peoples, strengthening tribal sovereignty. Thank you, Professor K.K. Stark, for being with us today.
Thank you very much. Am I able to share? Yes, I am. Everybody see the slide?
Yes.
All right. Bonjour, KK Kindigo, Benin Sink Women, Bishu and Tode, Meknakuturing and Donziba Dash. Nimi good train of my I know Mano Boom Chika Geekadurian and Nishnabe not Cornegawin. So my name's KK. I'm a professor at the University of Montana, and we're going to talk a little bit about the idea of how Johnson, some of those implementing doctrines, whether it's Doctrine of Discovery, implicit divestiture, or even the trust responsibility, can be thought about through tribal law principles. So also feel free to put questions in the chat, or you can raise your hand. We'll have ability at the end to answer questions. But even as I'm talking, if at some point you want to put them in there, I can look to address them at the same time. So kind of as Professor Collins was talking about, when we think about Johnson and the idea of the formation of federal Indian law, part of its development through the idea of conquest, through the idea of plenary power, has been the diminishment of tribal sovereignty. So as the United States has implemented assimilation policies from allotment to boarding schools to criminalization of Indian practices, those have all led to the diminishment of tribal sovereignty. And part of my argument is that we can overcome that through the implementation of tribal law principles. And two of the principles that I'm going to talk about and present as part of that process is both the idea of Minno Bimataziwin and the Komitizo. So to begin with the idea of sovereignty, so as Vine Delory Jr. said, you know, sovereignty is an ancient idea. There's been a lot of dialogue about whether the term sovereignty should apply to tribal nations. Should we adopt it as part of our understanding? And Vine was of the opinion that it absolutely applied to our nations and our understanding of our own governance, our own structures of, you know, being self-determining peoples. And part of that was that we operated both internally and externally. And so both amongst our own membership, our own people, and also externally with other nations, sovereigns, tribes, entities. So that brings us to obviously Johnson. So prior to Johnson, we had a number of treaties, treaty relationships establishing. The interesting part of what Johnson did, because essentially it created the preemptive right of purchase for the European nation, and the language of diminished sovereignty begins to be, you know, planted in the opinion. And so even this idea that tribes did not have complete sovereignty, it was limited. Part of the idea of domestic dependent nations created that idea of limited or less than sovereign authority. So you begin to see the seeds of diminishment planted in Johnson. And interesting enough, I mean, tribes entered treaties before and after and sold their land to other sovereign nations, to other individuals well after Johnson was implemented. There was a number of treaties with other foreign nations. We had treaties with Mexico, treaties with Russia, treaties with the Confederacy. that all existed post Johnson that everybody understands as being valid and appropriate. And so part of diplomacy continued even though Johnson existed. So from that idea of dependency and diminishment was the idea of domestic dependent nations. And so we see that both implemented in Lone Wolf and Kagama, the idea that part of the power and authority of tribes was limited because they were dependent upon the United States for both their political rights, for food, for resources. And so rather than a sovereign to sovereign relationship, this idea of dependency and diminishment was perpetuated. And so when we think of plenary power, part of that guardian-ward relationship that stems from the idea of where that idea of plenary authority comes from was drawn upon. And also you get the idea of plenary power coming from both the treaty relationship, part of the treaty clause and the Indian Commerce Clause. And so historically, if we use Kagama and Lone Wolf, the idea of the plenary authority was absolute. Congress could do anything with regard to Indian affairs. But we see some of that limiting. And a lot of it have argued that that responsibility should promote tribal sovereignty, that responsibility should be tied to either the treaty clause or the Indian Commerce Clause. And we've seen that both in Brackeen and Arizona v. Navajo Nation, where the discussion on how big and broad is plenary power. Both opinions really emphasize that it exists. It's beyond just commerce, but it's not absolute. And so there are some limitations as to what that plenary authority is. So with that, though, came the idea of implicit divestiture. So the idea was that we were sovereign, that pre-existed the establishment of the United States. We had this internal and external relationship, but however, our ability to have authority or sovereignty over our external affairs was diminished. And so that really, it's the foundation for Oliphant, the foundation for the whole Montana line of cases. But you even see it in Marion and Wheeler, and also Williams v. Lee, which we uphold as like a great opinion for utilizing tribal law. Part of it still had this language of diminishment over this external affairs. And so the idea was that tribes implicitly lost or had been divested of their authority because of their dependent status over external affairs, including non-members, their territories over non-member territories. And part of the rationale is that the Allotment Act and that, you know, the assimilation policies collectively was Congress's intent to diminish tribal sovereignty. And we know in order for Congress to diminish a tribal right, it has to say so. It has to be clear and expressed. And so we even see part of that emphasized in Castro Huerta, like part of the idea that, oh, this collective policy has created this diminishment of, you know, authority and allowed the states to creep into, you know, the realm of Indian affairs. And so you see some of that language continue. The court has still recognized this idea of divestiture. And so we have to emphasize that our treaties or provisions that Congress hasn't said so, that actually this whole idea that we have diminished authority as federal common law, the court made it up, and it's not really grounded unless our specific treaty agreement or documents, those policies that implemented for each of the tribes say so. And so unless the tribe said, hey, I forgo this authority in this document, they still have it. So we have to go back to those founding principles that in Indian law, we have to look at the specific facts with the treaty at question and the agreements at question, and all the policies apply to that specific tribe rather than this overarching idea that because someone potentially lost their authority, everybody lost their authority. So when we begin to think about plenary power as the diminishment, I always talk about it as a two-headed coin. The other side of the coin is this idea of trust responsibility. So rather than diminish authority, we have the idea to support tribal sovereignty. And so from that treaty relationship comes the trust responsibility. So we had over 400 treaties prior to 1871. Some have cited over 400 agreements post 1871. So there's a whole wealth and depth of tribal treaties, statutes, executive orders, and agreements that otherwise have the same bearing as treaties that have been implemented. And part of those responsibilities is grounded with the idea that the United States has responsibilities for protecting tribal sovereignty and protecting tribes and providing for their well-being. So from that, a principle is that the United States, in acquiring large tracts of land, has to keep its word and fulfill its treaty commitments. And so this requires the government to protect tribal sovereignty, not diminish it, respect Indian tribes, support tribal self-government, and economic prosperity. So we even know that the idea of the trust responsibility, even in Navajo Nation, to say that their water right was a bare trust principle, that there's no obligations that the United States actually has. So we even see cracks on the diminishment of the trust responsibility as part of this current court. So it's really important to emphasize, what those treaties, what those agreements, what the statutes say, protecting those rights that we otherwise reserved and ensuring that the United States upholds its obligations. So to think about that, I want to take us on a little trip thinking about Anishinaabe law. So as I began to think about, well, if we were to overcome these principles, how do we understand them ourselves from our own perspective? So I want to begin with the idea that we all subscribe to our own traditional law as our essential source of our jurisprudence. And so we don't have to adhere to the same principles that the settler colonial counterparts implement, right? We don't always have to follow Western law. Tribes are free to implement these principles in their own manner, what's appropriate for them, according to their own cultural principles. So knowing that comes the idea that we maintain this rich body of knowledge. However, it was rare to see that knowledge show up in our modern tribal court application. But that is starting to change. A number of tribes, including a number of Anishinaabe nations, are utilizing these traditional law principles in their opinions, and you're getting this whole birth of and depth of Anishinaabe customary law that's being developed. And so that's a positive thing of talking about these things, talking about these principles, how we can engage them and build them into the future. So when we think about, where our traditions come from, the idea is Anishinaabe is Yichigewi Nun, Minawago Anishinaabe Gapi, is Yichigewan Mewanjag Gayabi and Ma Ayamagud. So the idea is that those traditions, those things we had a long time ago are still there, and we can draw upon them and pull them forward and utilize them in understanding our law. So part of that is our oral tradition. So our oral tradition embodies our law, and it creates our collective body of principles and values that guide our way of life. And part of that understanding can be implemented through the idea of Indanaku Bijigun. So the word essentially talks about passing information across the generations. And so here's a picture of the idea of Indanaku Bijigun, which my son painted, and it references 7 generations. And the word itself is the same for great-grandparent as it is for great-grandchild. And so the idea is, as we pull from the past into the future, from great-grandparents to your great-grandchild, it's like that braid of sweetgrass, or some call it the string of DNA that our knowledge is passed upon. And so by implementing our knowledge and passing it along, we're able to transfer our stories, our teachings through the generations, through 7 generations, from great-grandparent to great-grandchild, through this idea of Indanaku Bijigun. So from that is the importance of our language. And so language serves as the teacher. It embodies our knowledge, our identity, our responsibilities, and it allows for that intergenerational transference. So if we're thinking of transferring these principles from the past into the future along that great sweet grass, part of that is through our language. So it's important that we utilize language in our law, our language in understanding what these legal principles are, rather than just translating them and using English equivalents by themselves, because it's our language itself that defines and holds, as a vessel that holds our knowledge. And so for the Ojibwe or Anishinaabe, our language is known as Anishinaabe-Moan or Ojibwe-Moan. And the idea is that the language itself establishes that connection from the past to the future. So if we think about Ndana Kubijigan, that continuous link across the generations is evidenced through our language and the transference of our knowledge. So this is important because each word in the language is very specific and it contains a story. So it's like this little bubble of knowledge that has its own etymology and structure within each of those words. So as we communicate those words and principles as legal principles, with it comes this broad range of knowledge and information that applies to those principles. So with that, we're able to transfer our philosophy. And this is important because I've heard a lot of people dialogue about tribes implementing language in their tribal code. What does it mean? What happens to non-members if we're going to apply the code? How do they understand it? And so part of the dialogue is that it's important to implement these principles, not only for the terms themselves, but the meaning within them. And so as we utilize our language, part of understanding, what those principles are is the ability to educate and teach the members, non-members about what those principles, those inherent rights are. And then also, as we begin to dialogue our legal understanding, because some said, well, what happens if you fight about what the word means or what the translation is? And to me, that's a beautiful thing. Like I always told tribal leadership that we would be successful if people are arguing in Ojibwe or about Ojibwe terms because they're actually engaging the law, they're engaging the principle, and then we've done everything we've set out to do. So to me, the utilization of the principles and the language itself is important. So when we think about those stories, teachings that's housed in the language and bring it forward, part of that's transferred through our stories. And so for our traditional stories, our spiritual stories, they're considered, the word is Adezukanan. And part of that is like the oral tradition that's passed on as part of our traditional story. And so the idea is that our traditional stories, Adezukanan, embody the collective memory of the people or the nation. And so from that, then our oral tradition provides the foundation for our law. And part of that then is embodied in our land. So our connection with the land is evidenced through our oral tradition, through what we understand as the term for ourselves, Ojibwe and Anishinaabe. So a lot of times people, their inherent words for themselves is the people or human beings, which is essentially what Ojibwe and Anishinaabe references. But literally, Ojibwe refers to our sound, Gidinwewinan, our sacred language, and then Anishinaabe refers to our creation story. And so collectively, it's our place that we put in upon the earth as part of creation, along with our sacred sound that embodies our sovereignty, essentially. So we use that term for thinking about sovereignty as that connection from place and through our creation story and the use of our sacred language, occupying that territory. So part of that's evidenced in the flood story. So we have both our creation story and then the flood story as a recreation. And so when we talk about title, Aboriginal title, Anishinaabe title, It comes directly from the flood story that created Turtle Island. And so from that includes all of the rights associated with the land as part of that narrative. And then when we think about the application of throughout our territory, through our sound, our connection with language, you know, on the US side, including into Montana, there's 52 tribes that are Anishinaabe. And then on the Canadian side, there's over 100 First Nations communities that are also Anishinaabe. So a vast territory, both sides of the border, that represent our territory connection with our place. So when we think of that territory, the earth, the idea is Gidikiminan, which is our earth, and that term establishes our relationship with creation. And so this interrelationship of how we interact with creation, the earth, is embedded in our term for law. So our term for law is Onakonagewin. And so this concept originates from the pipe ceremony. So Onakonage means to like point the pipe stem at the cardinal direction as part of the pipe ceremony. And so part of our word for law comes directly from our pipe ceremony, which is our connection to the land and our territory. And so we see the use of that interrelationship embodied in our term for law as part of our connection with creation. So here you see a photo of the pipe ceremony they did at the steps of the Supreme Court as part of the Mille Lacs v. Minnesota case. So part of that was embedded into those traditional encompasses of law, and part of what they did as part of that, implementing that case. So our term on Onakonagewin is our connection to the creation story through what we call the great laws of nature, or our treaty with the universe. And so to implement or explain part of that, one of our tribal elders, Campbell Puppetquash, said, "The Great Spirit made the great laws of nature for the well-being and the harmony of all things. The great laws govern the world, the movement of the sun, earth, moon, and stars. The great laws govern fire, rock, water, winds. The great laws govern the rhythm and continuity of birth, life, growth, and decay." So everything worked through those laws. And it is the law that everyone was ruled by, including all things in creation, and it is absolute, right? The basis of this law is peace. Before we can abide by this law, human beings must understand the frameworks of creation. So the idea is that even if we talk about natural law, or some talk about spirit law, traditional law, part of those aspects of our treaty with the universe is what governs those principles. And so that absolute law that, you know, governs our conduct and our responsibilities, that we have to acknowledge when we're implementing other principles of what we call Anishinaabe law today, which is like Indian law or human-made law. We still have these inherent responsibilities with these other sources of law. So as we talk about harmony, peace, our concept for that is Minobimataziwin, which is to live a good life, to live in harmony, to live in balance. So part of that idea of balance, harmony, is Minobimataziwin. And so our responsibility is that we're supposed to live, you know, by achieving that idea of balance on both the physical and the spiritual level. And our central goal as Anishinaabe is to exist in that state of harmony. So also it's important to think about harmony doesn't mean non-conflict, right? Harmony means that you're connected. And so if there is a conflict, part of restoring balance, restoring harmony is to address that conflict. So part of how we implement our law to achieve and maintain balance and peace, harmony, the good life is through trying to ensure that when things are out of balance, they're put back into balance. So this principle then shapes how we implement our law and legal systems. So part of the way we do that is understanding our connection as relatives. So And then away Maganadok is the idea of all our relations. So we're related to all things. And part of that is the idea of reciprocity. So in a way, Diwag means they are related to each other. And so when we think about kinship responsibilities, relational responsibilities, is the idea of reciprocity, because my obligations of how I'm supposed to treat you as a relative is supposed to be reflected back in how you treat me as a relative. So that becomes important. So when we think about governance, our traditional leadership, our word is Ogima. So the idea of traditional governance was that each of the clans selected their Ogama or chief or leader that's going to represent them at the National Council. So each of the clans had a seat at the National Council that was appointed by the other members of the clan. And so our word Ogama literally means recognizes those I'm responsible for. So collectively, the word Gaeji Ogama Watazit means to act in a way that recognizes those I'm responsible for. So this becomes our word, and then for governance. Some use it also for sovereignty, of how we're supposed to act according to our recognitions of responsibilities and obligations. So this becomes important when we begin to think about the trust responsibility from an Anishinaabe point of view. So when we begin to say, how are we supposed to act ourselves? We're supposed to act with Minnow Montezuma in mind, to live in harmony and peace. That has a reciprocal relationship with others, that we're supposed to get that in return. And then we appoint our governance and our leaders to act in that way that recognizes their responsibility to us. So we see that implemented through this idea of harmony, of how they're supposed to govern the people that comes from ourselves to then our families, communities, nation. So part of that idea of protection is gonna Wanjagazo. And so that term defines to be taken care of, protected, or kept. And so the idea is that if we're providing this idea of protection or guardianship and care, is that through the implementation of our responsibilities and obligations. Another word is Yoenjige, which means to be merciful, kind-hearted, or to have pity. So it's part of our word for love. And so how we're supposed to act through love, pity, kind-heartedness. And so when we think of that as governance, our leaders are supposed to both protect us and act through this state of love in achieving harmony, right? So both collectively, our idea of harmony and love is implemented of how our leaders are supposed to govern the community. So when we begin to think of the idea of Nakometizo, literally means to fulfill your duties or obligations. So it's like answering the call to step up and do what your duties tell you to do or ask you to do. So that becomes our word for like thinking about the trust duty. And so when we implement that, because we bring in that idea of reciprocity, that both of how we're supposed to live outward and then how we choose our leaders to act on behalf of the community, because it's reciprocal, other sovereigns have that same responsibility that's supposed to be emulated back to us. And so when those other sovereigns entered our territories, entered treaties, they agreed typically to be ruled by the laws that govern the land. So when we talk about our natural laws, those laws that govern the territory, it was understood by most tribes, and part of the diplomacy process was that these principles of kinship and reciprocity would be implemented and perpetuated back and forth. So part of the reasons why the governance process and the treaty process was really shaped by Indigenous governance. And so a lot of the early treaties, Treaty of Wampum, both at Niagara, treaty, and then what happened at Toronto, which was on both sides of the border, really created the foundation for how diplomacy in North America was going to be implemented. And these principles were foundational to establishing relationships, kinship, and then having these ideas of responsibilities to each other. So even part of the idea of the two-row wampum being renewed and implemented is the idea of renewal of these obligations. And so these principles were accepted by the other sovereigns, both as understanding, but also the idea that their commitments were based upon these ideas of harmony, trust, love, and responsibility. So with that, that can establish that path forward, grounded in our understanding of sovereignty rights and territorial governance, that we can utilize and take away, quit utilizing the idea of the doctrine of discovery and actually utilize these other principles of peace, harmony, love to implement how we're going to govern each other. And part of this rationale was utilized, as we talked about, in our traditional stories. So my article references Nanabuju and Maingan, which is our trickster, our cultural hero. And so part of his, both as being part half spirit, half man, he had all the flaws of being a human and all the wisdom, I guess, of being part spirit. So part of his interactions was laid out his responsibilities with his kinship brother, which at the time was the wolves, and how that was to be implemented. So again, our stories explain and support these notions of these principles being implemented as our law. So with that, that's my final takeaway, I guess, is we can stop utilizing the idea of doctrine of discovery, diminish sovereignty, and let's embrace our tribal law principles as we move into the future. So, any questions?
Thank you, Professor Stark, for the presentation. I do have an initial question to get the conversation started. I was wondering if you could share any additional thoughts you have on whether the great laws of nature or, other Anishinaabe laws around harmony and balance can hold lessons for responsible land stewardship for just everyone.
Well, I would say absolutely. So part of my thought and understanding is I think these lessons can integrate into all aspects of tribal law and tribal governance, but specifically with regard to our land. So you see that with how we're supposed to care for our resources, and then how we're supposed to implement both regulatory jurisdiction, and then management of those resources. So both on the regulatory side and the tribal management side can be embraced through these same responsibilities. So we think of the idea of wild rice. So for the Ojibwe or Anishinaabe, wild rice is one of our sacred foods. White Earth implemented its rights of nature codes, acknowledging the rights of the wild rice itself. And as a sacred food, we understand our elders tell us that how we actually governed each other was parallel to how we governed our resources and our wild rice, because it was based on kinship responsibilities, our same kinship obligations that we have in our communities. So how we're supposed to interact with grandpa and grandma and uncle versus our cousin, right? That most communities have. That it's the same extends to our land. So our idea of Mother Earth, grandfather sky, and all these kinship principles and how we're supposed to interact with our resources is also governed by these same principles. And so when we think of our duties, responsibilities to make sure harvest is sustainable, so a lot of our traditional laws with implementing around harvesting, so in the treaty rights context, we're guided by these ideas of sustainability. So when was the lake open for ricing? When was it closed? Could the tribe enact these principles? We're all part of that body of law that's been brought forward. So a lot of the treaty codes have some of these old traditional principles that a lot of community members don't even realize that they're embedded in these traditional laws, because that's just what grandpa said we were supposed to do, right? And so we're able to draw out some of these principles and how we govern the land and how we regulate that. And our next step as we move forward is really getting the other sovereigns to acknowledge that principle too. So if we're like, hey, tribes managing its territory, whether it's on reservation or off. So if you look at your traditional territories, treaty territories, sacred sites. So we begin to talk about co-management, co-stewardship, as tribes are implementing these principles to get the other sovereigns to recognize their responsibilities, like we're talking in the co-mitizo, to say, hey, you have these obligations, we have these duties to protect and care for the land. And you also have these duties with regard to the land. So let's collectively come up with this system of how we're going to govern and manage the land.
Thank you so much. It does look like there's something in the chat.
So chat says, how is your theory of tribal sovereignty compatible with constitutional rights applying on reservations, including 14th Amendment? To me, I think they're, well, absolutely compatible. But then the question is, what constitutional right? Right? So are we talking the Indian Bill of Rights provisions? Are we talking tribal constitutional rights? Or are we talking US constitutional rights? And so we know the US Constitution does not apply in Indian country, right? Which is why they actually implemented the Indian Bill of Rights, because there was this vast. So when we begin to talk about tribal constitutional law, it becomes interesting to think, well, what is in the tribal constitution, right? So is it a boilerplate IRA constitution? What if the tribe doesn't have a constitution? How does these traditional laws, are they constitutional in themselves? So part of the idea is you have to think about, what if the tribal constitution, as a perpetuation of maybe diminished sovereignty, conflicts with these traditional principles? What overrides the other? Can a traditional law actually declare a provision in tribal code or constitution as unconstitutional, which I think they could potentially, because of these duties, responsibilities that are foundational, right? And so whether it's the Ojibwe or whether it's the Dene with the, their fundamental law, a lot of tribes have implemented these ideas that your traditional law principles, have to override and govern all aspects of how the tribe's operating. And so one of the things to look at is, what does the tribal code say? Does their choice of law specifically call into question and the ability to use traditional law? Does it acknowledge it? A lot of tribal constitutions do, says we'll implement the tribal law and customs of the band, and then we'll go to state law or other law or written law. But if it's not in there, tribes need to think about putting it in there, right? Tribes need to think about embracing these ideas, creating these fundamental laws to govern them according to those principles that have, kept us all going for thousands of years. So at some point, if we lose the tribal connection from our law, then we become just like any other state or local government, right? We lose that coreness that makes us tribal. And so like I've seen different scholars and advocates say you can't take the Indian out of Indian law, right? You got to embody these principles, these tribal law principles. So question says, hasn't this already been decided against in Nevada v. Hicks, that tribes cannot overrule US constitutional law? Well, I would say it depends, right? Because now Nevada v. Hicks was kind of an offset case on specifically jurisdiction, but even the idea of jurisdiction is again federal common law. So we talk about implicit divestiture, the whole idea that feds have the ability to determine whether tribes have jurisdiction is actually just as artificial, because 1331 does not necessarily provide the foundation to analyze what tribal law opinion is. So again, that whole idea of jurisdiction is federal common law that's made up. At some point, the court decided that said, hey, we're going to review it and we have this authority and it comes from our treaties, but it never actually said so. Congress never actually declared, and tribes never said, hey, you can determine our own jurisdiction. And so even as an outsider in all those cases, it's important to implement those provisions, because we're seeing under the idea of the exhaustion doctrine that says, hey, we at least have to go to tribal courts first. We get to learn from the benefit of tribal court opinions. So we're seeing the more tribes utilize their own principles, whether it's of sovereignty, whether it's relationships. So how we define consensual relationships under Montana 1 can be defined directly in our own understanding of relationships. And so one of the great opinions about that is the Means case. And so in that, the Means case, Navajo Nation said our responsibilities, as an in-law creates a reciprocal relationship. So you have duties, you belong to the band, we have jurisdiction over you because of these relationships, and other tribes have those same principles that they can utilize. The other aspect is the treaty. The treaty itself extends their jurisdiction over their territory. So to me, tribal law can overcome those provisions. And yes, you still got the idea of the Supreme Court looking over your shoulder, but really, if they really look at the core and we divorce ourselves from these diminishment principles, then Nevada v. Hicks goes away, Straight goes away, right? Our principles move forward under the idea of tribal self-determination, self-governance, develop our own law. So, question in the chat, how are the Ojibwe traditions any different politically from any other utopian idea to be able to distinguish them? Well, I think part of the idea is not like a fully like utopia. So it's not, that's why the importance idea is that the idea of Vermont to Zeewin is not no conflict. It's like, how do we deal with conflict to achieve balance? And so a number of tribes have the same principle, whether it's the Ojibwe with Minnow Vermont to Zeewin, the Dene with Hosho, the Lakota Dakota with Wo Lakota. Like a lot of these principles of harmony, balance are critical to the tribal law principles. And so as you get conflict and things out of balance, you're able to put them back into balance based upon these principles. So it's not like this idea is like, we're Pocahontas where the birds are chirping and everything's beautiful. We understand that conflict exists, but it's how we deal with it to move forward in the idea of balance. So question says, what's your advice for how to showcase tribal law as a model for drafting state law in areas of land stewardship and resource management if the tribal law is unwritten? I guess you got to think about the principle and the principle of what you're laying out and how you would draft it up. And so we see some of that. So when we go back to the wild rice context, so in like the state of Minnesota, the state had no wild rice harvesting regulations for state harvesters. Meanwhile, the tribe, as part of the treaty rights cases, had implemented tribal wild rice harvesting restrictions that were really based upon traditional law that then the state adopted as state law to coincide. So both the tribes and the state had similar provisions. So it's one of those unique instances where traditional law was then codified into tribal law that then became copied into state law. And so I'm sure there's other examples of that. And so it'd be interesting as a project to like map out where that was, but then how do you define them? How do you utilize them? And you're seeing that in some of the co-management agreements, co-stewardship agreements of how they're managing the land, whether it's in a management plan or in the management principles, setting up how the various sovereigns are going to interact to get to that question. So I think there's examples out there that can be utilized to further the principle that, hey, states can borrow from this law or the feds, and as we implement these provisions. So we're seeing that somewhat in our cross-deputization agreement. So as we're looking at jurisdiction and some of those principles, and as we see more comedy amongst tribal courts and state courts about who's going to hear a case, whether it's in child welfare, divorce, whether it's sometimes traffic, sometimes that's going broader into drug courts, wellness courts, and how tribal and state courts are implementing these principles. It's creating that model of how tribal law can be borrowed and brought into the state forum as well.
Kind of going off of that question as well, and looping it back to your earlier reference to the rights of nature, I'm really interested in this connection, if there is a connection between tribal law, particularly Anishinaabe law, and rights of nature as we're sort of generally understanding it within the Western legal model. Would you say that Anishinaabe law is almost a precursor to the rights of nature movement? Are there more parallels you can sort of flesh out? Does Anishinaabe law really acknowledge personhood of nature in the same way, or is it distinguishable?
No, I say it absolutely does, which is why the whole rights of nature movement is typically tribes like the idea because it fits within their paradigm, right? Because when we talk about how our relationships with our land and our resources exist, and part of those kinship responsibilities exist, we know the rice is a being, right? The rice, Hamano is the idea of that rice man, that spirit that sits in the rice bed. So we understand it as being alive and a being that's overseen. Same as whether it's the river or the lake or that, mountain or that rock. And so we understand a lot of these entities or beings as being alive already, having spirit, having oversight, and then we have kinship responsibilities to them. So to build on the framework that, they are potentially live and have personhood, it's easy. The question is then how do you implement it, right? So my big takeaway on the rights of nature idea is, well, who speaks on behalf of that, right? Are we following these principles? If we're speaking on behalf of that mountain or that river, how do we know what that river is telling us, right? Are we utilizing these same principles? Are we bringing in what our own thoughts want to say should be utilized, right? So we have to think about and ponder, what the earth is actually telling us. And we see some of that through when we think about climate change now and phenology studies about how everything's changing. So what is the earth actually telling us? How that can come in? People sitting out there, whether they're fasting or, being with the land, how they can learn from what actually communicated. So then we think about, well, then how are we actually speaking on their behalf? And to me, it's not even that then that entity has to sue per se, but it's like, how do we implement our management collectively, whether it's tribe state, tribe feds, based upon those principles, right? So we don't even have to get into whether or not we have standing and we can sue, because if we're actually paying attention and listening to the land and the earth and that resource, then we should be able to manage accordingly and all get along, even though we have disconnect, we should be able to achieve harmony and move forward in agreement as to what's the appropriate management scheme to take care of that resource. So I think it's absolutely connected and can be utilized without even the lawsuit component, but under the co-management component, co-stewardship to be utilized. The question says, do you know of any use of the principle that governs a writ of habeas corpus within traditional law on behalf of nature? That is super interesting. No, but I think the principle applies, right? The principle of, well, if we think about responsibilities, like the idea like that we're being confined or locked up, and how do we go against that? Because if we look at traditional policing, traditional governance, like confinement was not really one of our principles, right? One of our principles was how do we achieve harmony, balance? If you don't continue to achieve balance because you like act accordingly, because we all had free will, right? So we were shaped and governed to like act accordingly according to kingship principles. And if you continue to act up, a lot of times you would be booted from the community, right? So you'd be banished and be like, hey, go live by yourself or create your own band, living according to those principles. So the whole idea of confinement becomes more complicated because it's somewhat foreign. So it'd be hard to think about how we would develop that as an idea of habeas corpus. But I think it'd be worth at least a thought. People think about it. Reading the long quote here. Right, so the big quote in there talks about the diminishment of tribal courts, tribal law, the diminishment of sometimes in its own regard, sometimes the tribe will diminish its own authority, right? And so we got to think about that. So as practitioners, tribal law practitioners, as training future tribal law practitioners, I always encourage, to think about that. What are the consequences of this opinion? What are the consequences of this case action? How are you going to implement these principles? What makes sense? And sometimes you want to just push back against the feds, right? Because the feds doesn't necessarily confine you. We're not limited to what Montana says, or A1, straight VA1 straight, or contractors, or Nevada v. Higgs, or Plains Commerce. Like, if we can implement our own principles, and we're seeing the courts actually adhere to them. So if we look at Water Wheel, we look at FMC Corp, if we look at Big Man, all of our new, because those are all tribal law opinions that were reviewed by, federal courts. And the more we engage these principles and actually acknowledge our law, then we're able to push forward and uphold them. And a lot of times the federal courts will just leave it and be like, yes, they decided that. And so I think part of the things we learned, specifically Professor Palmershine, because if anybody reads like Plains Commerce and Dollar General, like he was on both courts, and like how he like really engaged tribal law began to grow, because he understood we have to get into these principles and explain them, because someone else is going to look at that. The other aspect is to encourage federal courts to actually read the tribal law case, because in a lot of the early ones, they never even acknowledged the tribal law case existed. The more they've actually adhere to the exhaustion doctrine to say, hey, tribal laws exist, the court did these things, you're seeing this more respect for the principles of tribal law. So that's the other aspect. So not only build it, do it, not be afraid if they're going to push back, but then explain to the other courts what we're doing. And a lot of times they're going to defer to those tribal judgments.
In your opinion, do you see an upward trend in recognition of the legitimacy of traditional law on the appellate level?
I do. And I mean, obviously, we'll see what happens with our existing court if that shifts. But as of now, I see more legitimacy of tribal law, more legitimacy of those opinions. And part of it was, the more tribes are engaging it, the more tribes are utilizing it. I mean, part of our principle, even with the oral tradition, right? Part of the idea of oral tradition being important is the idea of it. What we hear and we decide to retell that story, right, goes to the elements of why that story is powerful and true and it's truth. And so if we think about as more tribes are engaging in these principles and putting them in their opinion and citing each other and saying, as this court did, we accept this, it just adds to the truth and the body of it. So again, we can have one tribe say, hey, these principles are important. But when we have 500 tribes say these principles are important, the courts are going to take more, reference to that. So the more we engage it, the more we embrace it, utilize intertribal common law across, whether it's, same or common tribes, all the Ojibways, all the Lakotas, all the, Pueblos, or borrow from each other. I think it just helps the foundation and legitimacy of what tribal law is in the eyes of others or external or federal government, state government. So we had the question, tribal courts having jurisdiction within the state court systems allows the experimentation and principles of Indian people to influence law. How do we create this integration? Can we do it giving real title to land to tribes, as has happened to some extent in New Mexico? I think we can do it in all aspects, right? So when we think about land back, as in, hey, I'm giving you the land back. So we see, like, whether it's at Blue Lake, part of the Chippewa National Forest at Leech Lake, they just gave them back. Part of Quinault. So we see all these examples of the return of ancestral lands to tribal nations. It can be through that, actually returning title. It can be through co-management, co-stewardship. It could be through all these implementation of jurisdictional principles. And so I think the more we begin to have relationships and cooperate with the other sovereigns, the better. And not only cooperate under the idea that, like, if we're having cross-credential agreements or like a tribal tax compact or otherwise governance compact with the state, that we always have to adhere to the state principles. We got to get those other sovereigns to adhere to our principles. And then we get this true relationship building. And so that's the element where we are today to build upon that. And we're seeing it in the wellness context, a lot of drug courts, wellness courts that are utilizing that. And they're understanding that these tribal principles on restorative justice are applying, and they're being applied broader into the community, both in state courts that, maybe go on off reservation, but even broader in some states. So that's a model that can be built out in other realms. So I think we're moving in that direction. We just got to utilize it. Any other questions? I think the last two in the chat were more common. Yes, I agree.
If everyone has asked all their questions, really great conversation. Thank you so much, Professor Stark. We appreciate you presenting and sharing this with us. At this point, let's take a short break. We'll reconvene right at noon Mountain Time, so in about 12 minutes for Professor Miller's presentation. Thank you so much again.
Thank you.
Perfect. Thank you. Thank you, everyone. My name is Alex Alvarado. I have the pleasure to serve as student articles editor for the Tribal Law Journal this year. It's been a great experience so far, and I'm honored to present our next speaker. Mr. Robert J. Miller is a citizen of the Eastern Shawnee Tribe and a professor at the Sandra Day O'Connor College of Law at Arizona State University, where he is also the Willard H. Pedrick Distinguished Research Scholar and the director of the Rosette LLP American Indian Economic Development Program. Bob graduated from Lewis and Clark Law School in 1991 and clerked for the U.S. Ninth Circuit Court of Appeals. He is the Chief Justice for the Pascua Yaqui Tribe Court of Appeals and sits as an appellate judge for other tribes. He is the author and co-author of 5 books. Thank you, Mr. Miller, for joining us. Please go ahead.
Thank you very much, Alex, and thank you, Rick and Vanessa and Kakake for your presentations, and I'm delighted to be a part of this conference. The 200-year anniversary of Johnson v. McIntosh, and just today I thought, well, this is the 20th anniversary of how long I've been working on this case. In 2023, my tribal council appointed me to be the Eastern Shawnee Tribe representative to the Lewis and Clark Bicentennial. And I was an untenured professor at the time. And I actually told my tribal chief no at first, because I thought, well, I'm a law professor, untenured, and Lewis and Clark's all just historical stuff. But then I thought, wow, I won't be here for the 300-year anniversary of Lewis and Clark, so I better take advantage of this 200-year. Because I then thought, what did President Thomas Jefferson know about Johnson v. McIntosh? What did he know about the international law of colonialism? Even though he sent the Lewis and Clark expedition to the Pacific Northwest 20 years before Johnson v. McIntosh. Well, I knew Jefferson was an attorney. I knew he'd been our Secretary of State, our Vice President. And then as I researched him more, he knew a lot about international law, the rights of indigenous peoples, the claimed powers of England, and then the American colonies, and then the American states in the United States. So I'm delighted I did get involved. I crossed the country multiple times with that Lewis and Clark, those signature events. If you remember, they put on 15 national signature events at different important locations. And I started giving my talk on the Doctrine of Discovery, started researching what President Jefferson knew about the doctrine. And then I thought Lewis and Clark were just country bumpkins. I didn't expect them to know anything about international law. But I learned that Meriwether Lewis was, even though he and William Clark only went to a couple of years of frontier school, Lewis was very intelligent. He was Thomas Jefferson's private secretary for 2 years, and they lived together in the White House, the uncompleted White House. And Lewis begged Jefferson to let him lead this expedition to the West. They engaged in activities that are very much the doctrine of discovery. I may not get to those points today because I want to mostly talk about how Johnson v. McIntosh and the doctrine of discovery have been applied worldwide. This is a very well-known American case, cited by Canadian courts maybe 70 times, cited by Australian courts maybe 40 times, and cited by courts in New Zealand maybe 20 times. The case is even cited in the British Privy Council. I know nothing about the English legal system, but I think this was the highest court of appeals for the Commonwealth of the English Empire. And in cases, 2 cases about Africa issues and 1 case out of Canada, Johnson v. McIntosh was quoted to the British Privy Council or cited itself by the British Privy Council. So I've ended up writing 2 books on the subject. My 2006 book is about Jefferson and Lewis and Clark and how the doctrine of discovery was used and then used in the US. And then I wrote an article with a professor from New Zealand, a Maori professor, Jacinta Ruru, and we compared New Zealand and United States application of Johnson v. McIntosh. We recruited 2 other Indigenous professors from Australia and Canada, and we published a 2010 book analyzing how England and then our own countries applied Johnson v. McIntosh and the doctrine of discovery against the Indigenous peoples of our 4 countries. I continued to be interested in the international application, and in 2011, I published 2 articles where I analyzed how Portugal had used the doctrine of discovery in Brazil, and then how Spain applied the doctrine of discovery in the New World, but I primarily focused on Chile. And so I will mention just very briefly some of the findings that I found from these countries. And I just want you to know that I call this more the international law of colonialism because that's exactly what it is. I'll show you some maps in a moment. We'll look at some papal bulls. This doctrine, this legal principle, was used to divide the world in half for Europeans to conquer and dominate and control, steal all the wealth, all the assets, etc. Finally, in 2012, I did a lot of research on Africa and how Africa was divided up by Europeans in 1884 and 1885. And I will talk to you probably most about that issue because that's my newest article. It came out in 2022, Duke Journal of Comparative and International Law, about how Europeans used this international law to carve up Africa. In the 1880s, 400 years after the doctrine of discovery was really created. This is international law, folks. In fact, the Europeans said, well, I'm getting ahead of myself, but when the Europeans met at the Berlin Conference from November of 1884 until February of 1885, they were codifying, they said, international law on how to colonize and carve up Africa. So this is a perfect example of Johnson v. McIntosh becoming international law, but Johnson itself was a replication of international law. I'm not sure Marshall created anything new. If you read his long 30-page opinion, he looked back at the papal bulls. He looked back at how England and France and Holland and Spain had colonized in North America. And he recognized that these were international law principles. And I'll be getting into those as soon as I can. I thought I was going to say something, Rick, I want to comment on your comment that Johnson v. McIntosh, I think you said not harmful. I say something to my class every year similar to what you said. If Johnson v. McIntosh had held that tribal nations owned the fee simple title to their lands, I wonder if we would have a single acre of land left today. And I think that's what you were inferring. State courts, individuals, non-Indian individuals would have defrauded us, would have stolen our lands if we held the fee title. And I think the state courts would have authorized that because it was all part of American manifest destiny and what God intended. I think, though, that there's a lot of harm that came from Johnson, and I think you would agree with me on this, Rick. Maybe we should comment at the end, but there's obviously racist bias represented in the case. There's ethnocentric bias. I will highlight this in just a bit. And there has been injury imposed on indigenous peoples, certainly around the whole world, and on indigenous nations because of this Eurocentric thinking that God intended them to have everything. And if you didn't know this, Rick, a professor from my old school, Michael Blum, wrote a law review article in 2004 in the Vermont Law Review and said similar to what you're saying and pretty much what I just said. Okay, I'm going to share my screen. Was that my introductory remarks? And I guess I've now been given an hour. Thank goodness, because I give this talk a lot and it will take an hour. Okay, I think. Can people see my slides? Alex?
Yes, you can.
Okay, thank you. So 200-year anniversary, Johnson v. McIntosh. There's been a lot of attention and lots of conferences similar to this one. The ABA is putting on one next week that I'm speaking at, and Richard Monette and Rebecca Sosi are talking. So what does the court hold? This country was settled on discovery and conquest. Now, I have word searched I've read the opinion many, many times. I have word searched it. They use the word discovery as a noun far more often than as a verb. And so they're talking, Marshall wrote, it was what, a unanimous opinion? How can I forget? I think it was 8-1, but I think Johnson concurred. I think, Rick, didn't you tell us that already? But discovery and conquest is what the U.S. title, what England's, France, Holland, Spain, what their title was based on, their claim to sovereignty. And the United States had inherited these powers by winning our Revolutionary War and by signing treaties with other European countries. What did it do to tribal peoples? Rick's already laid this out. It limited the tribal real property rights. Tribal peoples were not deemed to own the fee simple title. They could not, and still to this day, folks, tribes cannot sell trust lands to whomever they wish for whatever amount of money they get. The United States has an overarching interest, as we all know from studying trust responsibility and studying Johnson v. McIntosh, etc. As Rick mentioned, this is enshrined in federal law in the First Trade and Intercourse Act, July 22, 1790, which is still the law today, 25 U.S.C. Section 177. What else did the doctrine do, according to Chief Justice Marshall and the court? It limited tribal sovereign rights. So this is where I say that there's harm, there's injury. And here, let me just step back. These tribal property rights were taken by European nations and then the United States without the knowledge or the consent of the tribal nations and without any payment for the taking of property rights. So, gosh, I wonder what natural law would think of that. Chief Justice Marshall opines a little on natural law, and then I think he makes the statement, we have to look at the actual state of things. I think he uses that phrase 5 times in Johnson v. McIntosh. We must look at the actual state of things. What else did Johnson v. McIntosh do or recognize? Remember, it was looking backwards. And remember, the land purchases at issue here were from 1773 and 1775, before there even was a United States. The court is literally deciding if these alleged purchases by Johnson from tribal peoples and the corporation he controlled, were they valid under British law? I think that's why someone asked the question earlier about the Royal Proclamation of 1763. They were clearly not legal under the Royal Proclamation. And Rick's correct that we got rid of the Royal Proclamation, of course, when we won the Revolutionary War. But in 1783, the Articles of Confederation Congress adopted a resolution that is almost identical to the Royal Proclamation, claiming the federal supreme rights over buying lands from Indian peoples. So I will get into this in more depth, but that's what Johnson's talking about, a limitation on tribal property rights. Tribal nations could not sell their land to whomever they wished for whatever amount of money they could negotiate. They could only sell to the United States. Jefferson knew this clearly. 8 treaties negotiated during the Jefferson administration while he was president explicitly require the tribes to agree they will never sell their lands to any foreign country, to any individual, but only to the United States. President Jefferson knew all about the Doctrine of Discovery. Now I'm going to lay out for you, and I'll lay this out twice because I want to look at this more closely when I talk about Africa. But after reading Johnson v. McIntosh about 5 times, in fact, literally this happened between the time I wrote my article, which was my 10-year piece in 2005, Doctrine of Discovery in American Indian Law. One of my fellow professors took a look at this 122-page law review article and said, "You got a book here." And I went, "What?" How do I do that? So he showed me, he gave me a phone number for an agent, an editor, and they gave me one other person, and that's a person that edited the book that I came out with. So it was between writing the law review article in 2005 and then the book in 2006 that I thought about Johnson even more and more. And I reread the article or the opinion more and more. And I thought, well, what are the basic constituent elements? Just like we do with torts, folks, and just like we do with crimes, I started reading the opinion to see what the justifications were, the alleged justifications for this international law of colonialism. And I have discerned 10 factors, 10 elements that Johnson v. McIntosh relies on to justify this international law of conquest. What did Europeans rely on? Now, I'm going to cover these pretty quickly here. Well, maybe I should take a little more time because then we're going to look at a couple papal bulls real fast, and then we're going to look at a couple maps real fast and lay some of these points out. First discovery. This was, I think, Rick, you referred to this. Finders, keepers, losers, weepers. Who finds something first? Now, my next element, I'll refer to Rick's comment on possessions 9/10 of the law. So these are elements we learned in first grade, isn't it? Find something lost, we pick it up, we take it, and it's ours. We hold it in our hand, and that's 9/10 of the law. But first discovery was Portugal used this argument, Spain used this argument, England used this argument. Somewhere they arrived first, they claimed that that gave them, if not permanent title, at least an inchoate claim to having the title over the European Christian countries. Thomas Jefferson used this provision absolutely in the American claims to the Pacific Northwest, the Oregon country. The second element I perceived from reading Johnson so many times was that international law came to recognize that just because you saw an island or a landmass first, and maybe you even walked across it, but if you do not actually occupy it within a reasonable length of time, other countries can claim it. This element of the international law of colonialism was really developed by Queen Elizabeth I and her lawyers and ministers. And in the mid-1550s, she began to argue, and France began to argue against Spain and Portugal, that just because they had seen some island and sailed by it, they did not have a permanent claim to that landmass. They had to actually occupy it. Now, I digressed for a moment there because Queen Elizabeth was, of course, an excommunicated. She was not Catholic, she was Protestant. Why would she care what the Spanish country, the Catholic countries of Spain and Portugal and the Pope had said about international law in papal bulls? Well, don't overlook this, folks. Sure, she's a different country. She's of a different religion, but she would surely love those other countries to recognize her empire around the world too, right? It's very expensive to fight wars. It's much better if Europeans can just divide up the world because it's so large. I'll take this, you take that. Sort of be like me and Rick if we decided to take Cake's house. Cake, we're going to come over to your house today, and Rick and I are going to claim your house, under these elements. It's cheaper than if Rick and I fought a war and then go fight Cake too. So first discovery, important, but actual occupancy is crucial. I want to tell you something, I'm digressing here, but do you all know that Russia has been claiming that it owns the land under the North Pole? 25% of the Earth's known resources of oil and gas reserves are under the North Pole. Russia has tried to use the United Nations, the UNCLOS, the Convention on the Law of the Seas, and they tried to establish under the principles of that UN treaty that they owned the North Pole. They failed. But on August the 2nd, 2007, Russia sent a submarine like 2.5 miles below the surface of the water and stuck the Russian flag the bottom of the North Pole. You can see that flag online. Now, what? Were they making a first discovery claim to the lands under the North Sea, the North Pole? Unless they were just engaged in a publicity stunt, what was Russia doing? In fact, the Danish minister at the time, foreign minister, said, oh, Russia, this is not the 15th century. You can't go around the world sticking your flag in things and claiming them. Well, I don't know that Russia agrees with that. Now, I wonder, do you all know that China is claiming the South China Sea and is literally trying to drive the US, Vietnam, Philippines, Japan out of areas of the enormous areas of the South China Sea that China is claiming is its territorial waters? And can you guess what China did in August of 2010? I will pause. They sent a submarine below the surface of the ocean and stuck a flag in the bottom of the South China Sea. Now, is that a joke? Have you been following the news? Russian airplanes are flying very close to ours. Russian ships are sailing very close to US ships, very close to Vietnamese, Philippine, Japanese fishing ships, I think. There's going to be an international incident soon. And when Russia stuck its flag at the bottom of the North Pole, NATO said they would fight to contest Russia's claim to the oil and gas reserves under the North Pole. These are not just comedy, charades. They have real world impacts. Now, folks, what did the US stick on the moon in 1969? Wow. And who owns those moon rocks we brought home? Well, the US claims it does. Let me tell you, Richard Nixon had some of those moon rocks broken up into little pieces and put in paperweights, and he gave like 160 of them to world leaders, these paperweights with a little chip of a moon rock in it. One of them became available on the black market, and the US sued to get it back, claiming ownership. There's a case in the DC circuit about this. So a flag? Gosh, maybe this still is the 15th century. Cake, Rick and I are going to plant our flag in your front yard this afternoon. Be ready. Okay, first discovery. Portugal, Spain, the United States, England, all used claims of first discovery all around the world. Actual occupancy, which I've gotten to, every country, when they arrive in a new area, they attempt to build a fort or a trading post, or literally establish a settlement. Now, let me tell you what Thomas Jefferson knew about the Pacific Northwest. I should wait till I get to the map. Maybe I will. Okay, what's my third point that I perceived from reading Johnson so many times? When European nations came ashore, when they planted their flag and the cross, and they had priests with them to preach the Te Deum and hold mass, and then when they actually built a fort or town there, what rights did they claim? They claimed the right of preemption. This is 25 USC section 177 and what the United States claims over Indian lands to this very day. And remember, Johnson v. McIntosh came 30 years after that 1790 act. So the United States was operating under what was known as the International Law of Colonialism long before Johnson v. McIntosh enshrined it into American jurisprudence and helped to define what it meant even more. Everywhere European countries went, they passed laws and or regulations, and they prevented indigenous tribes and indigenous peoples from selling their land to whomever they want. Portugal and Spain engaged in this in Brazil and Chile. The Brazilian Constitution still has provisions on this to this very day. There are Chilean laws to this very day that limit tribal rights to sell their lands. After this, though, so Europeans acquired some sort of a title right. I think you're going to see with these two elements what we define as trust lands today, folks. The United States is the legal owner. The tribal nation, or with an allotment, the individual Indian is the beneficial owner. All well-recognized property rights but with the US having this superior right. Citation to authority, 25 USC section 177. And if you want to go a little farther back, the Papal Bulls, the Royal Proclamation of 1763, you name it. What else happened to, well, it's a native title. Chile and Portugal, Brazil passed laws in their colonial times, and even there's still a Chilean law from 1901 that controls the rights of the Mapuche people and their lands in Chile. What else happened to tribal rights? Well, this is straight from Johnson v. McIntosh. There was a limitation without their knowledge or their consent of their sovereignty and their commercial rights. The primary aspect that Johnson points to, and that you and I all know, is that tribes are deemed to be domestic, dependent nations. Of course, Marshall wrote that 8 years later, 1831, in Cherokee Nation versus Georgia. Tribes are limited sovereigns. Their powers are limited. They cannot engage in treaty making with foreign nations. Marshall even... Pardon?
I don't know. Did I call you?
No, I called you, but you said you were just thinking about it.
Could someone, thank you, sovereign and commercial rights. Tribes also had limited commercial rights because they were not supposed to trade with foreign countries. When Thomas Jefferson was our first Secretary of State, folks, he used all these elements right here in arguments with England about who owned the Pacific Northwest, and then later arguing about, I guess we'd call it the Ohio country, the old Northwest, the states that are now what? Wisconsin, Illinois, Indiana, Iowa, and Ohio, maybe. You can read letters. I quote these letters in my book of Jefferson writing to the British Foreign Minister, Sir George Hammond, and explaining to him that you can no longer trade with Indians south of Canada because those are our Indians. He said they can only trade with us. They can only sell their lands to us, the U.S. So Jefferson, as a lawyer from 1767, he practiced law full-time until 1764 when he got heavily involved in politics. There are 2 books on his practice of law. He handled something like 790 cases in those 7 years he was a full-time lawyer. And these authors say that something like half his cases were land disputes. Who owned the land? Who got the title from the Commonwealth of Virginia properly? So I'm arguing that Jefferson knew all about the right of preemption. He knew that the only legitimate title to Indian lands could come from the Commonwealth of either the King of England or the Commonwealth of Virginia once there was the Revolutionary War. One of the great debates, folks, in drafting our Constitution was who held the right of preemption between the 13 states or the new United States. And they finally agreed on the United States would own them. Virginia passed in 1784 its claim to the Western lands to the federal government. And the last state to pass its claims to the West, its right of preemption, was Georgia in 1802. And they extracted from the Jefferson administration a promise that the feds would remove the tribes as soon as possible from Georgia. And that was the condition. That was the quid pro quo for Georgia giving up its claim to preemption in the West. So I guess another point I'm making is Johnson v. McIntosh didn't make these points up. They were well understood for 400 years by the early 1800s. Contiguity, I'll show you a map in a moment. How big of an area did Europeans claim when all they did was walk ashore with their flag and their cross? Well, I'm going to show you a map of the Louisiana Territory in a moment. If that isn't the biggest claim of contiguity I've ever heard of, we'll look at the map. King James I used the idea of contiguity when he granted the charters for we used to have 17 colonies, folks. We always forget and think we just had 13. The king would grant these colonies 120 English miles around anywhere they built an actual settlement. And some of these charters were read to literally run from the Atlantic to the Pacific Ocean. They had no idea how far those two oceans were apart. But 7 of the 13 colonies were called landed colonies, and they had a claim clear to the Pacific Ocean. That's what Virginia ceded to the U.S. in 1784, and what Georgia finally ceded to the U.S. in 1802. Spain, Portugal, I'll show you the map in a moment. Look at what Brazil looks like today. Where did the Portuguese actually land? Just on tiny little pieces of the coast. But they claimed the entire what is today Brazil. Terra nullius. I think Rick mentioned this. This provision was used in Australia for the English to claim the continent. They looked around, they saw indigenous peoples, but they claimed it was empty. Now, I perceive in Johnson v. McIntosh 2 definitions of terra nullius, land that is actually empty of human beings. One seemingly can't argue with the fact that the first human being to show up can probably claim it. Finders, keepers, losers, weepers. But there's a second definition here. If Europeans did not view you as a civilized, organized government and people and culture, then they would call the land empty and available for European colonization. That is exactly the argument the English made. When James Cook landed near modern-day Sydney in April of 1770, Aboriginal peoples were throwing spears at him and drove him back to his ship. There were human beings there, but England still treated Australia as terra nullius until the Mabo case in 1992. Now let me go clear back to here because James Cook did some other interesting things. After landing near Sydney, modern-day Sydney, he sailed way up north and landed on what's called Possession Island. And he took possession as a first discoverer. I'll bet none of you know this, but James Cook was sent on worldwide expeditions allegedly for scientific purposes, just as Lewis and Clark were sent forth allegedly under scientific purposes, but actually they were sent forth for geopolitical claims to find new lands and to claim them for their home countries. And that's why I argue clearly Jefferson knew this international law, he knew these elements, and he used Lewis and Clark when he targeted them at the mouth of the Columbia River in what's today Oregon and Washington. But I get back to James Cook. He landed 3 times in what's modern day Alaska, and he went ashore and buried English coins in glass jars. Now, what a clever way. Just walking ashore and sticking your flag there and having the priest hold mass. Well, nobody sees that. There's no proof that you were really there. In fact, you all know, why is it called Cook's Inlet going into Anchorage? Why is the best hotel in Anchorage the Captain Cook? Wow. And there's a point on Cook's Inlet called Possession Point. And it's the very place Cook sent Lieutenant William King ashore and some of his sailors. They raised the British flag, they saluted it, they claimed the land for the king, they drank a good English porter to celebrate this acquisition, and they buried English coins in glass jars. Wow, that's a pretty good idea before you had GPS and I don't know what you call all those things. Okay, you can see why I need an hour, because I am not even through like slide 3. Conquest, military conquest was part of the Doctrine of Discovery. Do you realize the Doctrine of Discovery is one of the earliest forms of international law? The law of war and the Doctrine of Discovery are among the earliest international law principles. What's international law? It's the rules governments agree to comply with each other. What did I say earlier? War over possessions is expensive. It's cheaper just to divide stuff up. So any European or later United States or Australia or whatever government that won a war or a battle with an indigenous nation, they claimed all these rights over those peoples and their lands. But I also perceive, just as with terra nullius, I saw 2 definitions. I see 2 definitions with conquest. And this is the definition that Marshall relies on when he's talking conquest. The mere arrival of Europeans and the flag and the cross or the English coins was as if they had just won a military battle with the indigenous peoples, because they claimed all these rights over the indigenous peoples that we've been talking about, and that Johnson v. McIntosh certified. Now, I do not need to belabor over these last two for a second. If any of you know anything about international law and indigenous rights, Christianity has always been used as a hammer to beat us with, and that we are uncivilized and that Europeans are somehow civilized. That's another hammer that has been used to beat us over the head with and to justify European and American domination. Johnson v. McIntosh has this famous line. He almost disparages this, but he still relies on it. I can't quote it to you exactly, but there's this line out of Johnson v. McIntosh where Marshall writes that the potentates of Europe had no trouble justifying their acquisition of rights and land by bestowing Christianity and civilization upon the native peoples. Now that's a paraphrase, not an exact quote. I always go, thank you. You can keep your religion. You can keep your civilization. Give me my lands back. Okay. I'm going to go through this part pretty quickly. Let me see what time it is. Oh my goodness. Have I taken half my time? Portugal and Spain began to fight over the Canary Islands, which are located off the Iberian Peninsula in the Atlantic. In 1436, the Pope issued a papal bull granting Portugal the rights to colonize, Christianize, and civilize the wild, savage people of the Canary Islands. Did you hear three of the elements of the Doctrine of Discovery? Colonize, Christianize, and civilize these indigenous peoples. Well, Portugal continued. Portugal had developed the best navigation and the best sailing ships in the world and were going further than other nations. And they were going down the west coast of Africa, finding new lands, erecting what are called stone padroas, folks, along the coast of Africa and in Brazil. Spain, Portugal erected what are called padroas in Portuguese, a stone cross with the language, this land belongs to king, whichever the king was at that time, of Portugal. So they knew about first discovery. They were following this from the mid 1400s, and they finally turned to the Pope for more papal bulls. And I got to mention, I think, Vanessa, you mentioned the Pope withdrew or rejected the papal bulls. I would like you to read an editorial I posted online. That was a joke. The Pope said the Catholic Church was is not responsible for the Doctrine of Discovery, had nothing to do with it, that these papal bulls have all been withdrawn long ago and had nothing to do with European colonization of the world. The Pope literally, and then the Church from Canada, blamed scholars who have tied the papal bulls to European colonization. So the Pope didn't really withdraw these papal bulls at all. You can read that faster than I can. Look what Nicholas V issued in a bull in 1452, 1453, and then this one, granting just Portugal the right to perpetual slavery, to invade, subdue, kill all Muslims and pagans whatsoever. Wow, international slave trade started under the order of a papal bull, at least the international slave trade of Africans. Well, Spain was left out of all these papal bulls and was really mad about it. So when Columbus comes to them and says, I think I can go west and find new lands, Queen Isabella and King Ferdinand financed Columbus's voyages. Now, what'd you learn in school? He was just trying to get to India and Japan to get a good price on pepper and cardamom, right? There's a legal term for that. That's BS. Columbus signed 7 contracts with Isabella and Ferdinand, and only in the last one were spices even mentioned. All the other ones were about him finding new lands. And they promised him in that contract, we, quote, we will make you the admiral over any land you acquire for us, period, close quote. So the moment Columbus finds land in the New World, Spain turns to the Pope. It's time for you to give us some papal bulls and grant us ownership of these new lands. So the Pope issues 3 papal bulls in 1493, certifying Spain's claims to the New World. Look at the first element of Johnson v. McIntosh. Spain has the right to any land undiscovered by others. And I put in there, gee, what about the indigenous peoples? He also granted Spain lands if they had not been possessed by any Christian owner. So now he cut out indigenous rights. Now, Portugal was, well, here's in the same year, he issues Inter Caetera number 2, and I'm going to show you a map. He drew a line from the North Pole to the South Pole, granting Spain all these rights west of the line and Portugal the rights east. And they were supposed to convert the people, add to the worldwide Christian rule. Folks, I can't help but make a Columbus joke. Weren't you taught in school, same as I was, that people were afraid Columbus would sail off the edge of the earth? Who knew that the Pope knew there was a North and a South Pole? What are we taught in school? But here's the map, folks. Study this for a second. The dotted line in the Atlantic is the line Alexander VI drew. Notice it gives Portugal a tiny piece of Brazil, which they had not discovered yet. Let me think. I got to think a second about my dates. 1494. No, I think they did not discover Brazil until 1500. Boy, okay, there goes the memory. But they assumed there was a landmass out there. They assumed for the longest time that the hemispheres mirrored each other. And so just as Columbus had now found some islands in the Caribbean, the educated world assumed a bigger landmass. And Portugal did not want to cede that much of the Atlantic Ocean because if you know anything about sailing, to get around the tip of Africa, they needed to sail way far to the west, catch the trade winds, to then, catapult around the south of Africa, which they finally did round in 1498 with Vasco da Gama sailing on to India. So Portugal said, so much for relying on the Pope, but Portugal says, we'll go to war with you, Spain, if we're going to, and before we comply with that line. So look to the left there, the Treaty of Tordesillas. Spain and Portugal signed a treaty in the city of Spain in 1494 and drew the line where it is to where it became that bright red line to the west. Only later, look down in the right quadrant of it. Only later, once Magellan rounded the South America, did we find out about the Pacific Ocean. And so Spain and Portugal signed another treaty in the city of Zaragoza, Spain, 1529, extending that line through the Pacific. Okay, I think I had better hurry up. Now, England, I've already said, loved this international law because they wanted their empires and their discoveries complied with and agreed with by both the Vatican and Spain and Portugal to cut down on war. I've already mentioned Queen Elizabeth I and her adding this actual occupancy element. Henry VII was a Catholic monarch and was very worried about being excommunicated. Those papal bulls of 1436 and in the 1450s, they said any Catholic monarch that interferes with Portugal's property rights will be excommunicated. So he was very much worried about being excommunicated, but he was also very much greedy. So he sends the Cabots towards North America. They make their discoveries that the English claim gave them the rights in North America. He sent them under an order that said, go where no other Christian prince has yet been and acquire from me sovereignty, jurisdiction, and title. Elizabeth I did the same. James I did the same too. And his charters expressly relied on religion and the element of contiguity as reasons why England deserved this empire in the New World. Many historians write about our founding fathers' favorite scripture. Take a look at that. What do you think? Fill the earth and subdue it. Okay, I'll move on. I promised you this map. Thomas Jefferson, of course, signed the treaty that made the Louisiana Purchase. He thought it was unconstitutional and that the U.S. could not expand its borders under the existing Constitution of the United States. Other people convinced him to keep quiet and let's just take the land and run. Have you ever wondered what defines Louisiana Territory? And look up to the left side. What defines the Oregon country? This is the principle of contiguity that international law came to accept. The discovery of the headwaters of a river was meaningless. It was the discovery of the mouth of the river, and that gave the European or United States a claim to the entire drainage system. After making the Louisiana Purchase, folks, Jefferson spent the summer of 1804 home at Monticello using his library to trace the French explorations down the Mississippi and when they arrived at the mouth of the Mississippi and New Orleans. Because he knew that would give the United States, once we had bought this claim from France, that we would have a claim to the entire territory under contiguity. Now, I've got to ask you, what did we buy from France? Pause for a moment. Every article and book on the Louisiana Territory tells you it was the most valuable land purchase in history, and that the United States bought 800 million acres for $15 million. Well, I hate to upset the apple cart, but that is totally false. And you already know in the back of your mind the history that proves it's false. The United States spent the next 100 years dealing with the tribal nations in that Louisiana Territory, signing about 100 treaties with tribes, paying these tribes about $300 million, according to Felix Cohen, for the lands that the tribes ceded. And don't forget that those 100 tribes still have reservations and still have lands out there at this moment. What did the United States buy from France? They bought the preemption power. What did we acquire from England in the lands below Canada once we won our Revolutionary War? The treaty that ended our Revolutionary War, folks, said something like England cedes all its sovereign and proprietary rights south of Canada to the United States. We were buying not the full-fledged fee simple title, but this very valuable property right, which is literally an option. Those of you taking property law, this is an option. When you purchase from your neighbor the right to buy their land sometimes in the future, that's kind of like what the right of preemption is. And if you can trick your neighbor into signing an exclusive option with you, that if they ever sell, they will only sell to you, now you should be citing Johnson v. McIntosh and the international law. That's what we bought from France for $15 million, not the fee simple title. France had almost no citizens out there, had almost no, the only towns they had were on the Mississippi River, St. Louis, St. Genevieve, New Orleans. The Oregon country, you know, we all almost went to war with England. Do you remember what James K. Polk ran for office and what his slogan was? 54-40 or fight. Now, I wonder if any of you know what that means, but you know he didn't run for the presidency with a slogan that people didn't know. So everyone alive in 1844 knew what he meant. He was going to go to war with England if we did not get the entire Oregon country. Look how far the Columbia River goes up into British Columbia. James K. Polk was claiming to go to war with England over contiguity, over the doctrine of discovery, and the claim that America found the mouth of the Columbia River first in 1792. Lewis and Clark occupied it first when they built a fort at the mouth of the Columbia River in 1805. And then when an American fur trader, John Jacob Astor, built the town of Astoria, which is still today Astoria, Oregon, at the mouth of the Columbia River. Wow. Okay. Well, I'm not. How much time do I have? Who can tell me what to do? Well, no one can tell me what to do.
Just about 10 minutes if you can make
10 minutes. Okay. Well, I'm going to move ahead very quickly because I want to talk about Africa and the longest chapter in my 2006 book is something I did not write about in the 2005 Law Review article. I argue that American Manifest Destiny comes directly from the Doctrine of Discovery. The word manifest destiny was first used by an American newspaper in July of 1844 about Texas and the U.S. acquiring Texas. And the same New York editor wrote another editorial in December of 44, might have been 45, about the Oregon country. He claimed, we own it because God wants us to. We own it because we were there first. We occupied it first, and we deserve it. The word manifest destiny was repeated on the floor of the House of Representatives for the first time within just a few days. What is American Manifest Destiny, folks? We all studied this in school, but what did it mean? The U.S. is special. Our governments, our institutions are special. It's our mission to remake the world, and we're doing it under God's direction. I did not make these 3 points up. This is what historians, American historians, claim manifest destiny is. We're not the only country that has this idea. Chile came up with the Southern Destiny. Argentina talks about the conquest of the desert. And Brazil talks about the indigenous lands as being the last frontier and stopping the advance of civilization. So other countries in the world have adopted this same ethnocentric thinking that they're superior, they deserve the lands and assets of other peoples. So I'm going to conclude with my 2022 article. Portugal had long claimed parts of Africa under those papal bulls and attempted to settle and make colonies in Angola, which I believe is on the west of Africa, and Mozambique, which I believe is on the east. I could be totally wrong. France occupied Algeria, 1830. England got into Egypt. Germany began doing explorations. But the primary thing that started the scramble for Africa, and I borrow that title, there's even a book called that, but in Europe, this was the scramble for Africa. Grab it quick. King Leopold of Belgium, of course, occupied the Congo as a corporation, as a business entity, and in the most cruel exploitation of people and cutting off hands and feet for people to gather what do you make rubber of? To gather the rubber from plants and other assets. That the Prime Minister of Germany said, we've got to settle this. And so Otto Bismarck calls the Berlin Conference in 1884. What always intrigued me and why I started this research back in 2012, why was the United States at this European conference? 13 European nations met for about 3 months before they drafted the Berlin Act of February 1885. My research shows that the United States representative was to tell Europeans how to conquer tribal peoples. He was also there because the U.S. had an interest in Liberia, and of course, we wanted to have free trade in Africa. But why were we were not an official representative, but our representative gave several talks and, of course, was involved in all the private negotiations. The Berlin Act of February 1885 says it is international law. What international law is it, folks? Johnson v. McIntosh, and 400 years before that, the papal bulls, Spain and Portugal and the Vatican dividing the world. So I used, as in my article on Chile, as in my article on Brazil, I looked for evidence in the history of Chile and Brazil and in their laws, even to this current day, my 10 elements. And so with the Berlin Conference, I looked for, did these European nations, in essence, apply Johnson v. McIntosh? And the answer is yes. They used almost all of the 10 elements that I've identified. First discovery, absolutely. That's why this was literally called the scramble for Africa. Europeans were racing around Africa, trying to sign treaties with every chief they ran into, trying to build trading posts, trying to build forts to show where they had been and where they would claim empire. Now that sounds like the United States, doesn't it? And treaties in the United States. Berlin Conference and the Berlin Act uses the phrase effective occupation. A European country could only claim a colony in Africa if they effectively occupied it. That meant treaties with the local nations, that meant political relations with the local nations, that meant building a trading post, that meant developing the economy, that meant ripping off the people, of course, the indigenous peoples. There's no question that Europeans followed the first and second elements of the doctrine of discovery. Preemption and European title, I say the word by implication. Well, in the treaties that these European nations were, and folks, the number of treaties were incredible. Do you know Dr. Livingstone, that missionary? He was literally in Africa from the 1840s, and England used his work in Africa to make English claims to empire. The French sent a particular lieutenant, I forget his name, he signed about 100 treaties for France with indigenous leaders in Africa. The race was on, first discovery in essence, and then establishing political relations and diplomatic and commercial relations with the local peoples and local nations. The Europeans claimed land rights, and especially when they signed these treaties. Did the indigenous peoples know what they were signing when they said they would subject themselves to the European country that signed the treaty with them and no one else? That sounds like American treaties with Indian nations. That they would trade only with that European nation? That sounds like a lot of the treaties that our nation signed. Indigenous title, Europeans did recognize indigenous land rights. Why else would you be signing treaties with a local chief if you didn't think the chief had some sort of sovereign power to grant you, Europe, land rights, trade rights, and these European countries, in what looks like the trust responsibility, were ordered by the Berlin Act to protect the indigenous peoples. Yeah, they did that, just sort of like they did in North America. Native sovereignty and commercial rights, they were protected somewhat, but limited by these treaties. So they were recognized. You don't sign a treaty with just a family of 10 people. One country signs treaties with other countries. So just as in the United States, what European countries are doing was a recognition of tribal sovereignty by the indigenous nations in Africa. The history there, I studied this only a little bit, but the thousands of years of complicated forms of government, complicated forms of law that protected their peoples and their lands. Wow. Okay. Don't have time. Contiguity, absolutely. They didn't use the word contiguity. The Berlin Act uses the words hinterlands. And so Europeans claimed when they signed a treaty with this chief for this area of land here, and when Germany or England built a town on the coast, they claimed rights to enormous hinterlands. Terra nullius is not expressly mentioned in the Berlin Act, but I've read the transcripts. It was discussed at the conference, and Africa was treated as empty, especially for these claims to the hinterlands. Christianity, I put the yes in capital letters. What have European nations and then the United States and Australia, New Zealand, Canada, blah, 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 always claimed that heathen savages need to be civilized. So Christianity and civilization is heavily relied on in the Berlin Conference and in the Berlin Act. Conquest, I see no definition in the Berlin Act about what acts of war would give the European country. But I do see my second definition of conquest that I think Marshall used clearly in Johnson v. McIntosh, that the mere arrival of Europeans gave them rights over the indigenous peoples and limited the sovereignty and property rights of indigenous peoples. Here's a map, it's kind of blurry, but there's how 7 European countries divided up Africa, folks. My article focuses on East Africa. I focus on how England colonized Uganda and Kenya and how Germany colonized Tanzania. Now, it's called, I can't think of the right modern day word. just 10, I don't know, sorry, blanking. But I contrasted how the countries of Germany and England applied, if they did, the 10 elements of Johnson v. McIntosh. And my 2022 article absolutely argues that they did. Okay, to close my sign, I have to accidentally show you the covers of my 2 books. This is just an accident. But, you know, if you want to read that, and then here's the one that the shame of this, this is the cover of our 2010 book, written by 4 Indigenous peoples about how England and our countries, I'll be done in about 1 minute, use the Doctrine of Discovery against us. This painting is by an Indigenous person from Canada. The trouble is, my image doesn't show the whole painting. There's a cross stuck in this native person's forehead. And those 3 ships, if you didn't notice, are Columbus's 3 ships. He granted us the right to use this as our cover. It's about the most beautiful cover I've ever seen on a book, and so absolutely perfect for the message we delivered about what the Doctrine of Discovery has done, what colonization and the international law of colonialism has done to Indigenous peoples. And we're still fighting the harmful effects to this day. Thank you very much for inviting me. I certainly will take any questions if there's time.
Absolutely. If we want to take a minute for 1 or 2 questions, that would be great.
Oh, there's a question that's so long.
Dylan has a hand up.
I can't see that. If there's a hand up, I can take an oral question, and then there's this long post. Mr. Bluehouse, is this a question or information for us?
It's a reflection on thoughts that came to mind in your fascinating discourse on the history of the
Okay,
topic.
thank you. I'll read that later, and if you want to make a comment or turn that into a question, if we have time, feel free. But I'm told there was one hand up with a question. Oh, Dylan Wells, please.
Hi, Professor. I was curious, in your research, to what degree the European colonialists actually believed that Indigenous leaders had legal sovereign claims, and to what degree it was cynical?
In one sense, it was definitely cynical, wasn't it? Because it was just an argument against another European country. Oh, look, we have this treaty. This is what was going on in Africa, the race to sign treaties. But Dylan, I think there was a little more to it than that. The tribal nations were powerful. The tribal nations could have killed Lewis and Clark and their 33 people in their expedition just like that. So there was a real world, real politic, to use that word, need and requirement to recognize and honor tribal sovereignty. So I guess I'm sort of giving you a double answer. In one sense, it was a facade to use as an argument against other nations, but tribal sovereignty was very clearly a real thing and a powerful thing. And I gave a talk yesterday about American Indian influence on the U.S. Constitution and the Founding Fathers. And our Founding Fathers, our new United States was incredibly weak. It could not afford wars with tribes. They had to placate tribes. So treaty making early on was sort of favorable for tribal peoples. And the U.S. had to kowtow, and let's have diplomatic sessions, and here's gifts from us. The U.S. before the revolution was begging the tribes not to fight for England. And there were many treaty sessions and gifts. Call it a bribe if you want. Don't fight for England. So tribal sovereignty and power had to be recognized and was. Mr. Bluehouse, do you want to, if there's no more questions, do you want to turn your comment into would you like to say something or ask
Well,
me
actually, I'm
something?
going to defer. You have a question in the chat where a colleague is asking, is there applicability to it in Ukraine? So I'll defer there.
Wow. Well, I shouldn't comment at all because I don't know anything about this. I think Putin has done nothing more than naked aggression, hasn't he? When he took over the Crimea, he claimed, well, this is just part of Russia, always has been, we're just getting it back. I don't know that he's stuck the Russian flag in anything or the Russian cross. I hesitate to answer that question at all. I would think not. Somebody's asking about a recording. What recording?
Thank you. We'll be posting this on the Tribal Law Journal website, and we'll send a recording of the entire event to attendees.
Okay, that recording. Okay, thank you, Lauren. Okay, have I stupefied you into a comatose situation, or have I rattled your brains? I hope I've rattled your brains. Johnson v. McIntosh, 200 years, and I've been at it for 20 years, so I can talk about this subject for hours.
Thank you so very much, Mr. Miller. I think that was amazing. Everyone's really enjoying it. And it's my privilege to introduce our next presenter, Matthew Fletcher. So Matthew Fletcher is the Harry Burns Hutchins Collegiate Professor of Law at University of Michigan Law School. He teaches and writes in the areas of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, constitutional law, federal courts, and legal ethics. He also sits as the Chief Justice of the Pokagon Band of Potawatomi Indians, the Porch Band of Creek Indians, and the Grand Traverse Band of Ottawa and Chippewa Indians. Matthew Fletcher also sits as an appellate judge for the Cabazon Band of Mission Indians, the Colorado River Indian Tribes, the Hoopa Valley Tribe, the Lower Elwha Clallam Tribe, the Mashpee Wampanoag Tribe, the Machibenashawush Band of Potawatomi Indians, the Nottawasepi Huron Band of Potawatomi Indians, the Rincon Band of Luiseno Indians, the Santee Sioux Tribe of Nebraska, and the Tulalip tribes. He is a member of the Grand Traverse Band. He previously taught at the Michigan State University College of Law and the University of North Dakota School of Law. He has been a visiting professor at several law schools, including the University of Arizona, the University of California, Hastings, the University of Michigan, the University of Montana, and Stanford University. He is frequent instructor at the Pre-Law Summer Institute for American Indian students. He was lead reporter for the American Law Institute's Restatement of the Law of American Indians, completed in 2022, and has published articles in countless law journals. His horn book, Federal Indian Law, was published in 2016, and his concise horn book, Principles of Federal Indian Law, in 2017. Fletcher co-authored the 6th and 7th editions of Cases and Materials on Federal Indian Law, and both editions of American Indian Tribal Law, the only case book for law students on tribal law. He has also authored and co-authored numerous other books and articles, and the US Supreme Court has cited Fletcher's scholarship and advocacy several times. Finally, Fletcher is the primary editor and author of the leading law blog on American Indian law and policy, Turtle Talk. Fletcher worked as a staff attorney for 4 Indian tribes, the Pasquayaki tribe, the Hoopa Valley tribe, the Suquamish tribe, and the Grand Traverse Band. He previously sat on the judiciaries of the Lac du Flambeau Band of Lake Superior Chippewa Indians, the Little River Band of Ottawa Indians, and the Turtle Mountain Band of Chippewa Indians. And he also served as a consultant to the Seneca Nation of Indians Court of Appeals. So without further ado, I hand over the floor to Matthew Fletcher.
All right, thank you so much. That was definitely my bio, and very long. And I'm sorry I didn't tell you to shorten it. Hope it didn't take up too much time. So I'm here to talk a little bit about Johnson versus McIntosh. And I guess if there is a theme to my presentation, it would be about education and practice, more than sort of the history and the sort of the practice of Johnson versus McIntosh. So many years ago, I wrote an article as a recent law grad that I labeled Listen. I called Listen for the Michigan Journal of Race and Law. And portions of that paper are about my experience taking property. In the first day of property, we talked about Johnson versus McIntosh. And my professor at the University of Michigan, who I liked a great deal,
He was self-deprecating, which is a rare trait in practice at Michigan Law, on the Michigan Law faculty. He had never taught property before, had never really even practiced law in a traditional sense, and it was all brand new to him. And he made that abundantly clear first day of class. And he's basically saying, look, bear with me. I'm in this with you. And I like that about him. And then we talked about Johnson versus McIntosh. And I have no memory of anything of substance he said. I think he spoke briefly in an apologetic way, but this was a case that I could not and did not understand at the time I read it. I still don't think I truly understand Johnson versus McIntosh. It's helpful to hear Bob Miller talk about just sort of the basics of what it is, but it still is a case that just I find absolutely befuddling. And I suspect that that's one of the reasons why Indian law took so long to become an issue or a class that is taught regularly in law schools. I started law school in 1994 in the fall, so it was the early part of January in 1995 that I began my property class. And, there really wasn't a tradition of teaching Indian law at the University of Michigan or any other schools in the state of Michigan at that time. I guess if we go back into the past of the mid 90s, you would probably see a regular class at schools like UNM, Arizona State, University of Washington, maybe Tulsa, University of Oklahoma, UCLA, and after that, maybe hardly any. And it's changed a bit, but I really think that first day in property where our professor, who was new to teaching and maybe didn't really know any better, was actually willing to put himself out there a little bit and say, here are the things about an Indian law case. And I really think that it took that for most professors and scholars and practitioners who don't really do much Indian law, they are afraid of it. They don't want to mess it up and they don't want to be called out for being wrong. And I think that's why, for the most part, why Indian law doesn't appear very often, even to this day, in regular law teaching classes. Indian law should be in constitutional law. There should be more of it in property. Should be more of it in all sorts of classes in the first year. And sometimes you'll take an entire semester and not have a single Indian law case. And I think that's because people are afraid of it. And in some respects, that's good for the rest of us because then we have a market for our scholarship and as law professors and especially as practicing lawyers. But it's kind of troubling that it's so complicated and scary that nobody wants to mess it up or talk about it or take it seriously. After law school, I went out and practiced in-house for Indian tribes. And today I'm doing double duty. I was also on a couple of panels for the annual conference of the Tribal In-House Counsel Association. And, one of the things that I both expected and didn't expect about what I learned about Indian law in law school, which is very little, was that Johnson versus McIntosh is actually quite prevalent as a symbolic matter. I'll talk in a little bit about why I think it's probably not all that relevant as a matter of law, but as symbolism and as rhetoric, it is very, very important. And so there were two cases that I want to talk about that are property related that unfortunately for me, I didn't serve as the attorney for either of these cases, but the attorneys who did argue these cases they have my gratitude and my respect. These are hard cases. The first one is a case involving the Hoopa Valley tribe and a woman named Roberta Buganig. And Hoopa is a tribe located in Northern California, about 300 or so miles in the mountains north of San Francisco. So I've only spent a little bit of time at Hoopa. I lived there for about a year, but it still chafes me when somebody says they're from the Bay Area and they say they're from Northern California. That's simply not true. But the Roberta Buganig case involved a lady who was a non-member of the tribe, a non-Indian, who bought an allotment within the reservation at Hoopa. Hoopa has, like I said, it's in the mountains. They have a lot of timber. They fight with the United States about water all the time, and they have a really interesting, robust religion rooted in the place. The whole reservation, in some respects, is a sacred site. And Boganig bought this land, and the story goes that she promised to, she was going to cut down about an acre of timber and leave the rest of the 40 acres, the timber on the 40 acres standing, even though it was, from her perspective, fee simple private property. She could do whatever she wanted with it. And there was a weird jurisdictional loophole in that the state of California did not assert jurisdiction over her land. The federal government, more or less, did not do that either, because it wasn't federal land, and the tribe was the only government that was asserting the power to regulate her activity. And so she challenged it naturally, and on all the federal Indian law grounds you can think of. And ultimately the case reached an en banc opinion of the Ninth Circuit that affirmed the power of the tribe to exercise jurisdiction over that land. And what she was doing was, like I said, she was going to clear cut some land and build a house on it, a retirement house, and use the proceeds from the timber that she cut to build a house and retire there. But that's not really what she did with it. She clear cut the whole thing, and she lied. And during the pendency of the litigation, which started in tribal court and went for many years until a cert petition was filed and then ultimately denied in the U.S. Supreme Court, she clear cut the land and, I imagine just made an ungodly amount of money. And so what's interesting about this case to me is that Johnson versus McIntosh is not the kind of thing that's going to appear in any of the pleadings. But if you think about what Johnson is about and what Boganig was about, was tribes' power to decide what the property rights and the legal regime of a given territory are going to be. So in Johnson versus McIntosh, we know that the tribe sold land probably in accordance with their own customs and traditions. And it's not entirely clear to me, based on some deerskin maps I've seen, that the parties to the case were even talking about the same areas of land. They weren't really speaking in a serious way to each other. And land speculators at that time weren't serious people. They were just running out, trying to find any Indian they could who would sign on a piece of paper that they could rush back to the colonies or the original 13 states and say, see, we have land here. It's all just pure speculation. And I use that word in the broadest sense because it really was a bunch of stuff that was made up. And what we get with Boganig centuries later is a tribe that actually does have the power not only to decide its own property rights regimes within its own territories, but actually the power to enforce them. And that's a little bit different than what we had with Johnson v. McIntosh, where the tribe can say one thing, but in the end, the tribe's not even a party to this case. Ostensibly, they're long gone by the time settlers come in and stay for a permanent period of time on the land that issue in Johnson v. McIntosh, which is really quite a tragedy. The tribe in the Hoopa case had adopted a rule that any land located within a buffer zone that loosely corresponded to sacred sites on the reservation could not be developed, except through a very rigorous and restrictive zoning protocol that the tribe had adopted. Effectively, Roberta Boganig was in that buffer zone, and under tribal law was not allowed to clear cut her land. Like I said, she did it anyway during the pendency of the litigation. But I think that says a lot about what tribes are interested in and what they use the land for. And Johnson v. McIntosh says a lot about what Americans thought land was. It was commerce. It was a piece of paper, and didn't really even matter if anybody occupied it. It just was a thing for people to transact over hundreds, if not thousands of miles away. It's really fascinating to me. The second property rights case I want to talk about is actually two cases that my brother Zeke Fletcher litigated over the years, called Patchak cases. And Patchak was a non-Indian guy who lived in a town nearby where I grew up. I grew up in Allegan County, specifically Wayland, and Patchak was a guy who had some property nearby. And the local tribe is the Gun Lake tribe, the Matchibenashiwesh band of Potawatomi Indians. Most of my relatives are enrolled there. And Bradley, just outside of Wayland. And they wanted to get some land in trust and open up a casino. And it took a long time for them to get to that point. And they actually litigated, the Department of Interior litigated on their behalf when Interior decided to take land into trust in the early 2000s for the tribe, and they were challenged. And back in those days in Michigan, there were all these fake organizations, sham groups that would come up and sue the Department of Interior for fee to trust acquisitions. And every Potawatomi tribe in Southwest Michigan had to go through it. And they were organizations that had silly names like Citizens Exposing Truth Against Casinos, or CTAC, or Michigan Taxpayers Against Casinos, or that one was called TOMAC, Taxpayers of Michigan, excuse me. And then there was Michigan Gambling Opposition, or MISHGO. They all had cool acronyms, and it was all the same people, the same attorneys represented the organizations. And Patchak ostensibly was a part of at least one of the organizations, I think MISHGO. But MISHGO lost. They lost all their cases. And then the United States Supreme Court decided a case called Carcieri versus Salazar, where the court said that a tribe not federally recognized or not under federal jurisdiction in 1934 was not eligible for the fee to trust statute. And so Gun Lake tribe was not federally recognized in 1934. So the question would become, were they under federal jurisdiction in 1934? And I can tell you a lot of my relatives were taken to boarding schools during that period of time, including my grandmother and all of her brothers and sisters. So to say they weren't under federal jurisdiction is pretty damned offensive, but we never got to that question. So Patchak sued the Department of Interior over this land on the theory that it was effectively his land. You know, he was saying that it offends his aesthetics to see an Indian tribe doing business within territory that he was used to seeing as being white. And I'm paraphrasing to some extent his claim, but that's really effectively what it came down to. And ultimately, the U.S. Supreme Court in Patchak 1 said that he had standing to claim that his aesthetics were injured, and that constitutes standing in fact under the Administrative Procedure Act. And then the court said that the United States did not possess sovereign immunity to block his challenge. So the case was remanded back to federal district court. And for 2 years, I didn't hear anything about it from my brother. I see him pretty regularly. He lives about a mile away. We get together once in a while and have a beverage together. And, you know, he just never talked about the case. And, you know, it's hard to go to the Supreme Court and lose a case. It hurts a lot. And I always just assumed that he didn't really want to talk about it for various reasons. He would say occasionally that Patchak apparently didn't have an attorney anymore and never could afford one in the first place. So maybe the case would just die like that. But turns out what he was doing was he was going to Congress every few months and developing a statute to reverse the Supreme Court's decision in Patchak 1, which Congress eventually did. And that's when Zeke started talking to me about the case again. He didn't want me to put anything on Turtle Talk or say anything about his legislative strategy for the tribe. And it was an incredible success. But of course, it had to go to the Supreme Court one more time. And the court ultimately, in a split decision without a majority opinion, ruled in favor of the tribe. And you'll probably not hear these words very often out of my mouth or anybody's mouth, but in an opinion, lead opinion from Justice Clarence Thomas affirmed the statute in favor of the tribe. So you can't make this stuff up. But really what Patchak is about, I think, is another story of Johnson versus McIntosh. I mean, Johnson versus McIntosh is taking lands that legally have a character that is indigenous and transforming that into something else. And, you know, probably for decades after Johnson v. McIntosh, none of the tribes at issue in that case probably even heard of it or knew anything about it. And it's the kind of case that nobody paid attention to for literal centuries after it was decided, until we started teaching it in property classes in the 80s, I think, is probably when that started. So they're taking the character of land and changing it into non-Indian land, even if the land itself remains effectively indigenous. And once that change happens, I don't know if Johnson v. McIntosh says this, but I strongly suspect once that change happens, that Americans think it's permanent. It can't be undone. This land can never go back to having an indigenous character again. And we see this in cases, not so much Patchak, but cases like City of Sherrill versus Oneida, where the tribe tried to buy its reservation back, and the Supreme Court said, that's really cute, but you still don't get a tax immunity just because you own your reservation again. And that brings me to sort of my thinking about the paper I put together that I need to develop further, which is question of political theory. I think if you really want to know what America stands for, Johnson versus McIntosh is a really good place to start. Don't read the Declaration of Independence or the Constitution or the Federalist Papers. Johnson says everything you need to, but you really have to work to think your way through what Johnson is saying. As Bob Miller was saying earlier, that how you own property in the United States and Western political thought is by developing it, by exercising dominion over that property. And this is at core the difference between Western and indigenous political thought, is that humans are not here for indigenous peoples to exercise dominion over anything. Anishinaabe people will say, yeah, humans were created last by the Creator, just like in the book of Genesis. But unlike the book of Genesis, humans are not created last because they're the most important. Humans are created last because they're the least important. That dominion over anything by humans is literal imbalance. And humans have the potential for superpowers compared to all the other creatures. We see this every single day. Humans have superpowers. They are free will and the power to dream. But they also have a super responsibility that we tend to ignore. Western political thought not only ignores it, but it affirmatively rejects it. It's a responsibility of balance and harmony. And humans are assumed under Western political thought to be selfish and violent. And the only thing that can stop us from exterminating ourselves is a national government, a sovereign. The sovereign could be a church leader like the Pope. But it has to be someone with monopoly on violence that can coerce human beings, individual humans, into complying with the rule of law, into protecting private property and guaranteeing security from crime for everyone. And without this sovereign, or what Thomas Hobbes called a Leviathan, human life would have ended many centuries ago. But here's the thing, we know that to be empirically false, because you have hundreds, if not thousands, of tribal nations, indigenous nations in the Western Hemisphere that were the exact opposite kind of governance, a governance rooted in harmony and equality, a governance that doesn't have a hierarchy that's a pyramid style, it's more of a circle. And an understanding that humans owe at least as much to the creatures in the universe around us and to each other as we do to ourselves. And that political philosophy is the future. It has to be, or else, in fact, the humans will probably go extinct. I mean, I look at Western political thought and I look at Johnson v. McIntosh as a direct manifestation of that, and I see a suicide pact. There is no way for humans to survive, or anybody, anything on this earth to survive, given the enabling of incredible selfishness by a limited number of people. And I'm in the middle of a rant, so I'll slow down a little bit, and I'll try to end with sort of a humorous question that I think is humorous. I've been asked so many times in the last year or so, does it really matter that the Pope rejected the Doctrine of Discovery? And I'll tell you my answer, and then I'll stop right there. The answer is no, because if it mattered, that people would be burning America to the ground right now in order to protect it from the Indians. And there would be riots in the streets, but it doesn't matter. So that's basically where we are in the world right now. I'll stop right there. I'm happy to answer some questions, and thank you to Eliza for her great comment Appreciate it. I guess you can raise your hand, or I see you there, Rick. It's really good to see you. Do you have a question?
Do I have a question? No, but
no, okay.
It's great to see you, and I haven't even sent congratulations on your Michigan appointment.
Oh, thanks. Yeah, it's like coming home. Appreciate that.
Yeah.
I see Milton has a question.
Yes, thank you so very much for your very thoughtful and humble approach to a conversation that I feel sometimes is more or less esoteric. And so what I oftentimes catch myself thinking about is the conversation I've had with my late father, where he would say to me, is this Cadillac knowledge or is it reservation truck knowledge? Right.
Yeah.
And so we were always focused on the reservation truck knowledge, right? The practical application of what knowledge does to impact positive change in our communities. And so maybe this is a question that I'd like to explore with you, is that with the esoteric discussions related to Johnson versus McIntosh and the wonderful, absolutely fascinating historical background, how does this knowledge, right, impact things like the social determinants of health in our tribal communities, right? It goes back to that issue of, I mean, how do we resify this knowledge so that it makes a difference out here? Thank you.
No, that's great. And I don't have a great answer for that. I do have lots of ideas. One of the things I think that we can talk about in reservation communities that is truck knowledge, and maybe it's not truck knowledge, maybe it's lawyer Subaru Volvo knowledge, but it has to do with how we define property in tribal governments and tribal codes. And I think tribes are kind of already there, sort of implicitly. When property law is devised in state, federal, and local governments, it's almost always devised to protect first the interests of the people who possess most of the property in the first instance. And if there's anything left after that, then the protections conceivably can trickle down. And we know that as a tradition in Anglo-American common law that people used to be property. We know that from the history of the United States. We also know that from family law, the origins of family law, that a woman and her property were effectively the property of her husband. Children were the property of their parents. And you can even see this in as a joke in episodes of The Simpsons where Homer references his kids as his property. And if you look at how state child welfare systems arose, they arise in the context of treating children as I was going to say collateral, but chattel is the word I'm using. They're pieces of property. I recall taking a torts class where the professor told us at common law that the wrongful death tort of killing negligently allowing a child to die or killing a child is of negligible damages, because children provide nothing of income to the family and are huge expenses upon the family. And so if one dies under the common law, there was no damage. It was actually a benefit to the family because there were fewer expenses imposed upon the family. And I think if you look at something and drill down into stuff like the best interests of the child standard, which is how state and tribal courts decide where to place children that are in need of care, whether it's with a foster family or to keep the child with biological relatives. That is kind of the meat of where do we think of this child as a piece of property, as an expense, or do we treat this child as Anishinaabe people would do, as a literal supernatural creature called Benojin, that is a spirit that comes forth. We don't treat those individuals as property, and it's little subtle things like that that make a big difference. I think tribes are already doing this thing. I know Navajo and Hopi and a lot of the Pueblos have been doing it for decades. And we're just starting to incorporate some of this into Anishinaabe governance up here in sort of the more assimilated Western Great Lakes. But you're starting to see tribes in Minnesota, Ojibwe tribes, and Michigan tribes especially adopting codes that are rooted in tribal codes that are child welfare codes, property codes, even election and membership codes rooted in our customs and traditions like Minnow-Madswin and the Seven Sacred Teachings, things like that. And you, of course, have the Menominee Statute that came out of the White Earth Nation Ojibwe. And that's much more interesting than what you would see tribes do a half century ago when we were sort of totally assimilated in a lot of respects. It's still not right truck driver stuff, but it's, you know, reservation lawyer Volvo stuff, rusted out Volvo stuff. Other questions? Go ahead, Mr.
Hi.
McBride.
Thank you very much. My name's Dean McBride, and I'm a non-native, but I'm a tribal court judge in a couple of tribes, the Tonto, Apache, and Mason, and recently Pojoaque, and just recently, like this week, Pojoaque here in New Mexico. And I guess, you know, as I'm contemplating this role, and I don't know how many other non-natives are dialed in today, but, you know, I'm always wondering how to approach my cases and approach this area of law with humility and with respect. So I guess I wonder, do you have any advice for me or someone like me of how we internalize the learnings from today, how we take this and make this practical, and again, how we operate from humility and without hubris in this space?
Well, I feel like it took me a long time to reach the point where I am now, and I don't know where I'll be in 20 years either. So there's a couple of things I think that tribal courts do sort of without really even thinking about it. They've already internalized. And, you know, if we were to extrapolate that out to federal and state courts, we'd be talking about things like the right of access to justice. For example, you know, the federal rules and state rules of civil procedure are designed to keep poor people out of court. That's why they're so complicated, why they're so formalistic, why you really need to have a lawyer to navigate them. And, you know, tribal courts don't have to be so specific about, so picky and formalistic about who gets to go to court. And I spent a lot of time as a tribal judge patiently listening to someone who's not trained in the law, just giving them a chance to articulate their claim. And the kinds of claims that I often hear as an appellate judge would never have been heard at all in you know, they never would have been heard at all in terms of like state or federal courts. These are issues that, you know, people just need a chance. And classically and infamously, the Indian Civil Rights Act doesn't require tribes to provide attorneys, paid counsel for indigent criminal defendants. And, you know, that's still a serious problem in Indian country and other places where tribal communities don't have the resources to pay for counsel for indigent clients. But the tribes that can do that absolutely do in a way that, you know, I think is really inspiring. I mean, I look at fights here in Michigan and Wisconsin over whether or not the state is going to fund a public defender office, right? Or what kind of funding they're going to provide. And, you know, it's embarrassing that that's the kind of thing where all the pressures politically are to push it down as weakly and make it as weak as possible. Whereas tribes, if they have the resources, are going to spend them on things like a defender system. And expand that out broadly to more things like child welfare programs, you know, to try to reunify families and prevent the difficulties that families have. So I would say that tribes are already sort of doing this thing. And, you know, one thing that if I would make one piece of advice I would give to non-tribal attorneys who may not as be familiar, or judges who may not be as familiar with the community, is to just assume that if you had a justice system, you could start from scratch, where you could throw off all of the things about federal and state courts you don't like. You can assume that the tribe isn't going to like that either. I'm pretty sure you can. Things like qualified immunity. What is qualified immunity? Where a police officer can beat somebody almost to death, and if there wasn't a Supreme Court statute or a Supreme Court case that held that that exact fact pattern was not constitutional, then they're totally free to do it until a court somewhere along the line says that it's unconstitutional, even if it's their case. And that sort of thing is baffling to me. It's rooted in a hierarchy and a sovereignty structure that is just antithetical to what most people think of in the US. It's not just Indians. So just if you see something that you don't like in the law, even if it's tribal statute, it's okay to say something and question and ask, why are you doing this? What is this about? Maybe you can't do that in a given case, but you're not going to be hearing cases every single minute of every day. And there is a pretty decent interaction that can occur between tribal judges and the tribal legislative branch, even in a strong separation of powers situation where you can engage, maybe with the legal department or something to that effect. And I think those are the things that are useful for tribal judges to know, and that may or may not happen much in state or federal courts. I suspect it happens very rarely. So
Thank you.
Any other questions?
Professor Fletcher, I think there's one question in the chat, if you can see that.
Hold on. Okay, here we go. Do you see assimilation as wiping out tribal values rather than allowing integration of tribal laws and customs? Well, I mean, the goal of assimilation, of course, from the colonizer was to wipe out tribal values and exterminate Indians, but it didn't work. So what I do see is tribes kind of looking for a way, as they develop their governmental structures as a general matter, from complete wreckage. Keep in mind, the United States for 200 years destroyed our governments, and we're starting from literal scratch, like the ground up in a lot of contexts. And there are going to be a lot of shortcuts, and one of the shortcuts is to do things like borrow federal and state law sort of en masse, or large chunks of it, and just say, at least until we get on our feet, and then we get our shit together, then we can go back and rethink these things and try to reincorporate our traditions. And that's a really hard thing to do, because then you end up stuck with state and federal type laws, and you end up getting stuck in what economists call path dependency, where it just becomes easier to do it this way. It's really hard to develop law. That Minoman statute didn't just fall out of the sky. I mean, people worked on that, I would imagine, for a lot of time, and it required a lot of creativity, a lot of knowledge about Anishinaabe values and the language, and those things are, the people who know those things there are not very many of them. And so to get all of that together and put together such an interesting statute really is pretty rare, but that is the future. And so assimilation, I think what we should call it is attempted assimilation or attempted genocide. But tribal nations are still there, even the ones that in the East that really went underground for decades, if not centuries. If you went to Mashantucket Pequot when they first opened the casino, you're probably going to, my understanding is, because I wasn't around Connecticut around that time, but my understanding was that they were really starting restoring, redeveloping, re-understanding their traditions and histories. And if you go there now, it's a lot different story on just what the outward facing projection of the tribe's culture and history is radically different. They have a museum, an amazing museum, I understand. So assimilation is attempted assimilation. We'll conclude with that, I guess. I think I see another comment from on traditional tribal ADR practices. Helps a lot too. I totally agree. I know that in Michigan, the tribal courts have worked very hard in trying to divert juvenile and nonviolent offenders, first-time offenders, into a non-criminal justice structure. And I think it's done some really good work. We really don't like to criminalize addiction. But that criminalizing addiction, criminalizing poverty is really the core of American criminal justice. And so if tribes are going to adopt that structure, they're going to be head down that road just like everybody else. And it's really hard to roll that back, but tribes definitely are seeing what should be obvious to everyone, that most crime is caused by poverty, and addiction is also caused by poverty. So I agree. Rick, go ahead. I see your hand up, finger up.
I thought of a question about Johnson versus McIntosh, that one of its obscure provisions that isn't paid much attention to is where the court said that by buying the land, these white guys were subjecting themselves to tribal law, which of course is a lot better than what the Supreme Court eventually decided tribal authority is over non-members. Comment.
Well, I totally agree. I actually, with a former student of mine, wrote a paper about how the colonizers bought into the Anishinaabe commercial market. The way they bought into it was marrying Anishinaabe women, the children of other Anishinaabe women who actually owned the trade routes and all of the markets. So under Anishinaabe law, a lot of Anishinaabe Kwe were, as a matter of culture, controlled the markets and controlled access to trade routes and that sort of thing. And so they bought into it for sometimes decades or even centuries. The law on the ground remained very indigenous, very tribal. But as you know, those things, the demographics tend to change, and the relative fortunes of each government, federal, tribal, and state, tend to wax and wane as time goes on. So I understand completely your point. And Milton asked about my background. Yes, it was a native writer, native artist who did this, and I've since forgotten who it was, so I apologize for that. Any other questions? Well, I'm looking at the list, and it's not, I feel like I should call on people like Nadine Padilla, who was my student at one point.
Okay, well, if the questions have slowed down, I think we're going to move on to closing remarks. I wanted to thank you, Professor Fletcher, for your time today, and I also wanted to thank you for teaching me at PLSI. It was a great summer. But yeah, today was an amazing day. We had a great symposium. We had amazing turnout, and I want to thank everyone who made today possible. I want to start by thanking everyone who attended today for listening to our speakers and for your thoughtful questions and comments. I also want to give special thanks to our wonderful speakers today, Professor Collins, Professor Stark, Professor Miller, and Professor Fletcher. I also want to give thanks to our introductory speakers, Dean Camille Carey and Professor Racehorse. I also want to thank the editors and staff of the University of New Mexico Tribal Law Journal. Without all of you, this wouldn't have been possible. So thank you all so much for coming to the symposium today. I hope you all have a great evening and go and have some fun for the rest of your day. Thank you all so much.